Test, test, test. Test, test.
Please be seated, and good morning, everyone. Welcome. Our first case for argument this morning is Yoram Khan versus Walmart. Mr. Bernstein?
Good morning, Your Honor. May it please the court. My name is Stanley Bernstein for the plaintiff appellant. Happy to be in Illinois this morning. ICFA, as Your Honors know, is intended to eradicate all forms of deceptive and unfair business practices. And it's to be liberally construed to effectuate that purpose. ICFA prohibits misrepresentations or any conduct likely to confuse consumers. What does plaintiff allege? That Walmart, the largest retailer in the world, has a widespread, pervasive, company-wide practice of posting lower prices on its shelf than it charges at checkout.
And Mr. Bernstein, what is the factual allegations on which you base that statement that Walmart is engaged in a company-wide, pervasive, and continuous false advertising campaign?
The complaint details specific purchases by the plaintiff for purchases that were overpriced. The complaint details similar purchases in 6 states. The complaint details fines that Walmart has paid in 2 states for violating the posting requirement. And the complaint also details, to add insult to injury, that we went back to some of the same stores that Walmart has been fined for this practice, and the same thing happened.
So one of the cases that you cite is, I think, Lee versus Kohl's, right? Where a case that alleged similar kind of pervasive conduct. But in that case, they had basically a consultant or an expert do kind of a systematic statistical analysis over time that was a bit more rigorous. And I'm wondering what sort of selection process that did you go through as you're going to these Walmart stores? Were they randomly selected? Were there statistical evidence done? Because right now, what the complaint seems to allege are just kind of individual cases, and there's nothing about what sort of selection process it was, whether it was randomized or whether it was selective.
Your Honor, we're on a motion to dismiss. We've alleged it's pervasive practice. We believe we've alleged.
Well, you've alleged it's pervasive practice, but that's why I'm asking, can you give me, that seems a bit conclusory to say it's pervasive. And my question is, what are the best facts that you've alleged that would indicate that would support that?
We send shoppers into stores, other shoppers into stores, randomly purchased items, and we find this practice over and over again. The confirmation of the practice, to be quite blunt, Your Honor, was in the amicus brief from the Retail Federation. They confirmed for us, and the National Retail Federation is chaired by the president and CEO of Walmart, something that wasn't in their brief that we learned later. But they confirmed that this is their practice. Their practice is to change the prices in the computers before they change them on the shelf. And when they get around to changing them on the shelf price is correct. So to answer, I think that probably is you don't need a statistical analysis. They have told us that 100% of the prices are wrong until the shelf price gets changed, because they change the computer prices first. They don't have to do it that way. They can do it, as we say in our reply brief, the other way around. Change the shelf price. They have so many computers at Walmart and so many scanners and so much technology. Confirm the shelf price is accurate, and then change the computer price.
Well, I guess along similar lines, if I might, you're invoking jurisdiction, the court's jurisdiction under CAFA, right? And so one of the requirements is that the jurisdictional amount has to exceed $5 million. As I read the complaint, at least for your putative class representative, Mr. Khan, I believe he was overcharged in total about $1.89. With regard to numerosity, your complaint alleges that there's hundreds of thousands of customers, right? Well, hundreds of thousands times 1.86 doesn't really get you to the $5 million mark. And so I'm wondering, again, kind of what the basis for the good faith allegation is that you have an amount in controversy over $5 million.
Thank you so much for asking. If only 2% of Walmart's products are overpriced, which is something that my friends at Walmart think is acceptable, only 2% of our products are overpriced. And if they're only overpriced by 5%, which is a very, very modest overprice, because typically this happens when the prices get raised, and the prices get raised 5%, 10%, 15%. The math works out with a company that does $400 billion of sales per year to be a windfall to Walmart of $400 million per year taken from consumers and given to Walmart just on overpricing. And our experience is 2% is a low number, and the 5% is a low number. But as far as reaching the jurisdictional threshold, this we think is quite easily done. And of course, that would be a class certification issue and a jurisdiction issue, but the math works out like that. And I've used very conservative numbers in that example. It took me a while to do the math too, because my calculator doesn't have enough zeros for Walmart sales. But you rip off consumers $1 at a time, $1 at a time, $1 at a time, and you're Walmart, you get there real fast. These are classic ICFA violations, we believe. Walmart's been repeatedly fined for this, and it doesn't change the practice. And as I mentioned, it is so easy to change that practice. There are electronic shelf registers that could be done. They have a scanner they can scan when the label is changed. But they don't do it. Why are we here? Because the district court erred, we submit respectfully, by misinterpreting ICFA, misinterpreting the cases decided by this court and the Illinois Supreme Court and the Illinois Circuit Court to hold that simply providing a receipt after a purchase negates the deception before the purchase. We argue that's wrong, and perhaps more importantly, with a little bit of humbleness, the Illinois Attorney General has put in an amicus brief that says that this decision is antithetical to ICFA.
Mr. Bernstein, do you agree that you're seeking a form of strict liability under the Illinois statute?
It's not really strict
where
liability.
it's essentially as long as Walmart intends for consumers to rely on the prices marked on the shelves, and there's a discrepancy in their favor, that's a violation.
Our case is not a strict liability case because we claim they know what they're doing.
But
there are defenses.
The question is whether you have to prove that and under the ICFA.
We have to prove that they intend for us to rely on the prices and look at the totality of the circumstances. We've alleged that they intend for us to rely on prices. Otherwise, why would they put the prices on the shelf? Why would it be required by law? Why don't they just say, pick up an item and when you check out, you'll find out?
So how is this different from strict liability?
There are defenses because theoretically they could establish a policy that you don't rely on the prices. They warn you, like in the Tudor case, which we might get into. I'm watching my time very carefully. Unfortunately, all the preparation doesn't prepare you. In Tudor, they told the customers basically back in the 1990s when scanners were new, don't rely on the prices as a practical matter. The scanners may be wrong. If we're wrong, we'll give you the item for free. So it would not be strict liability.
Okay. And then one of the questions I had is, what does your unjust enrichment claim add to your case here?
I thought that question might come up. It rises and falls with ICFA. It gives you restitution. So perhaps a different remedy than under ICFA.
What's your remedy under the statute?
The statute, they overlap. They do overlap, Your Honor.
I'm just wondering whether they aren't completely congruent.
Well, we're asking for restitution.
Okay.
We're asking for corrective action, injunctive relief. But they do overlap. So, ICFA prohibits any misrepresentation or any act that would lead to a likelihood of confusion. Putting a shelf price up that says $1 and you charge $1.10 is likely to confuse most consumers.
Do you see any difference, Mr. Bernstein, between a minor discrepancy of a few cents, let's say, on a tube of toothpaste, and let's say $100 discrepancy on the price of a television in terms of reliance, susceptibility to deception, and so on?
Honestly, no. If they put up a price tag that they intend for us to rely on, and then they change that price secretly and don't tell the consumer, that is a deceptive practice. These are not innocent errors by one clerk, which our friends at Walmart would like you to think. This is the plan. This is in the amicus brief. They've confessed. We alleged there was pervasive practice. Your Honor asked me specifically, was it just random? Was it just 6 states? So far, we have evidence from 6 states. I thought that was enough to allege. This was not a 9B motion. This was just a 12B6 motion where the court just said a receipt voids everything. And that's really why we're here. And that cannot be the law.
But a $100 discrepancy in Judge Hamilton's hypothetical would more readily be noticed by the consumer at the time of checkout when the receipt comes up, right? So it's harder to call that deception than minor errors such as those that are alleged here
It depends, Your Honor, on what the price was.
that would be overlooked by the consumer until later.
It depends what the price of the item is. If the item was a $2,200 TV set and you checked out and it was $2,300, you might not notice. Consumers, the law is, do not have to audit their receipts.
I think the point is that this is contextual. We can't apply the fraud component of the statutory claim without some factual allegations suggestive of fraud, deception, and intent to deceive, or not intent to deceive, but intent that the consumer rely on the mispricing on the shelf. And that means something more than just the price discrepancy itself. It's the price discrepancy plus some other facts, whether it's the receipt and all of the other facts that were in the Tudor case. It was not just a receipt in the Tudor case. It was the money back, not just the money back guarantee, but the item for free guarantee.
Item for free, yes.
Which went beyond a refund. But the other facts that were present in the Tudor case took that case outside of what could reasonably be called an adequate pleading of fraud. And we have to get beyond, we're here on a plausibility standard. If the evidence, or if the allegations, are in equipoise and they're as easily interpreted as inadvertent random price discrepancies as they are interpreted as fraud, then dismissal was appropriate. But you've got to point us to the plus factors.
The plus factor here, Your Honor, is we've alleged a pervasive practice that they have confessed in the amicus brief is the practice at Walmart and others, that they change the prices, I'll say on Saturday night in the computer system, and they get around to changing the prices on the shelf whenever they get around to them.
They put the lower prices in the night before, and then they change the shelf pricing to reflect the lower price.
The higher price. They put the higher price in the night before. When they raise their prices, but they leave the lower shelf price on the shelf indefinitely.
So they don't input the sale price the night before.
They don't put the sale price. I'm talking about prices going up.
Oh,
sale prices, they're quick on changing the shelf to advertise a sale because they want to encourage you to buy a sale price. It's when the price goes up is essentially when the consumer gets damaged because they charge you more at checkout. Now, I have 6 minutes left, which I wanted to reserve for rebuttal. I do want to make.
Can I ask you one thing, Mr. Bernstein, if I may, along what Chief Judge Sykes was asking about the context, the factual context. Do you know whether the Walmarts that are mentioned in your complaint had point-of-sale register displays?
I don't know. That was something raised for the first time in the reply brief. The point-of-sale register display might go into the totality of information that's available to the consumer. But Walmart, unlike Tudor, does not tell you don't rely on the shelf.
No. But I'm just wondering whether or not you know as a factual matter
I do not know.
Whether the Walmarts had such displays.
I don't know.
Or whether they were legally required to have such displays in these states.
I don't know.
Okay.
I don't know. I do know this, that the legislature in ICFA, Section 11A, says this act shall be liberally construed to effect the purposes thereof, to eradicate all forms of consumer deception. The Illinois Supreme Court in Olivieri and Robinson said ICFA should be utilized to the utmost degree to eradicate all forms of deceptive and unfair business practices. It is unfair to change the price on the computer, raise the price on the computer, and leave the consumer not aware of that price change. And as a practical matter in this court, in many court cases, in Bell v. Publix and all the cases we cite, Bell v. Publix and Benson v. Fannie Mae and Vanson v. Hills, some of them didn't even have a specific misrepresentation. Some of them had confounding information. The truth was on one side, the falsehood was on the other side of the same package, and this court held that that was potentially deceptive under ICFA. Here we have the exact information being a falsehood. The shelf says $1, and you check out, it could be $1.20. That is a violation of ICFA. And under Bell v. Publix and Benson v. Fannie Mae and Vanson v. Hills and Kim v. Carter's, the Seventh Circuit ruled that just saying what a suggested price would be was a violation of ICFA, even though the consumer was paying the actual price that was advertised. Here we're not paying the actual price that's advertised. So this is only a motion to dismiss. I have about 3 minutes left, but I ask Your Honor to consider the following example, which I believe is in our brief. You're driving down the highway and you see an advertisement at a Shell station. It says $3.09 a gallon. You drive in there, you fill up your car, you go home, you look at the receipt from the glove compartment, and it says $3.29 a gallon. That is deceptive. And to ask about the point of sale, maybe the $3.29 was on the fine print.
It's deceptive even if I notice the price as I'm pumping, right? Because I've taken the time to pull off the highway, and I don't want to look around for another gas station.
That is when
we're talking here about sunk costs, search costs, and so on from what behavioral economics tells us about.
Absolutely. And this court has said consumers shouldn't have to do these things, and Walmart doesn't have to do it. But I have 2:45 left. I'd love to reserve that time,
That's
please.
fine.
Thank you.
Is it Bluen?
Yes. Good morning. May it please the court. This case centers around plaintiff's contention that an inaccurate shelf price is per se unlawful. Those are not my words, Your Honors. Those exact words are set forth not once but twice in the plaintiff's brief. That's the underlying point that they're trying to make throughout this entire lawsuit, is even in a simple situation where an honest mistake is made, my client should be held liable. And it's not just for a dollar.
Is that what they're saying, or are they saying that based on that allegation, they should be able to survive a motion to dismiss? Those are two very different things, right? Because certainly, as we all know, the totality of the circumstances and the context matters, but plaintiffs aren't obligated to allege all of those factual contexts that might harm their case in their complaint. They're only obligated to allege enough where, taking all inferences in their favor, we think they might be able to state a claim in some plausible manner.
Very true, Your Honor. And if I could, and I'll go back, answer that question, and simultaneously answer the question that you proffered to Mr. Bernstein. Let's look at the facts that are specifically alleged in the complaint. What we have here is this individual, I think it's clear, it's certainly reasonable to infer, that when he went to Walmart on August 2nd, he wasn't shopping for muffins or donuts. He was shopping for a lawsuit. That is fairly clear, I think. It's not a leap of faith to reach that conclusion.
He was a tester.
He was a tester, Your Honor, and so much so that immediately before, immediately after he left Walmart, he walked down the street, literally on Touhy Avenue, to Target and did the same thing and filed an identical lawsuit against Target. So he was seeking discrepancies here. He was seeking mistakes. I don't think that can be credibly disputed. Now, with that as the factual backdrop, what did he find? He allegedly found 6 items Your Honors, I don't know if any of you have been in a Walmart. I'm guessing you probably have at some point, but I think it's safe to assume that there are hundreds, at least 100,000, 150,000 different items at any Walmart store at any point in time. So that's our frame of reference. Let's be conservative and say 100,000. What did this tester, the plaintiff, find when he was shopping for this lawsuit? He found 6 items. 6 out of 100,000. Equally important.
But you can't test until you actually go to the cashier, right?
I disagree, Your Honor, and here's why. And I forgot, one of Your Honors raised the point about the point of sale system. Yes, I believe, Judge Lee, you were the one that asked the question. Yes, Walmart has those systems in place, and yes, they're required to have those systems in place, certainly in Illinois. I can't stand before Your Honors and tell you I know the state or the laws in all 50 states in that regard, but in Illinois, I can tell you that, and the specific statutory site is set forth in our brief.
Meaning you can scan and see what the
You
scanner
see
price is, and if there is a
exactly, Your
discrepancy.
Honor. Before there is a sale that's consummated, before the receipt is printed, you scan it if you're at the self-checkout, or the cashier scans the item, and the price comes up. So if there is a discrepancy, whether it's the $100 discrepancy for the TV that was referenced, or the dollar discrepancy, or the 42-cent discrepancy for the muffins or cupcakes, you have an opportunity to identify that discrepancy before you hand over the cash or your credit card.
And if the consumer is actually monitoring that, right? And we also have, I mean, retailers invest an awful lot of money into researching actual consumer behavior, right?
Correct.
And every cashier I've ever been around, I'm surrounded by impulse items, right? Candy, gum, magazines, distractions, the latest celebrity divorce, and so on. Everything to distract me from paying attention to whether the scan prices match what I saw and might remember.
True, Your Honor. I guess hypothetically, I will tell you, I understand the point.
Well, part of the question, what I'm really getting at, is the question whether in applying these consumer protection statutes, we should be focusing on Adam Smith's rational economic actor or actual consumer behavior.
Your Honor, first of all, with respect, there are no such allegations in the complaint, which is what we're talking about here
No,
today.
but that's a responsive theory to your insistence that a receipt washes away all potential for deception.
Your Honor, first of all, we haven't taken the position that a receipt in and of itself absolutely is dispositive here. It is a factor. It's a clearly important factor, as the Illinois
Okay.
Supreme Court said 25 years ago in the Tudor case. We are not saying that the receipt in and of itself is dispositive. We are saying that it is a highly significant factor. The totality of the circumstances is the appropriate test here. We cited numerous cases. My opponent cited numerous cases. There's no dispute about that.
What's Walmart's policy on price discrepancies?
There's a variety of policies that apply. First of all, Your Honor, Walmart has a total refund policy. I believe off the top of my head, it's a 90-day. I think it's a 90-day, 30 or 90 days. No questions asked, absolute refund in place.
And
There's
what's the
also-
state of the record on that?
There's nothing in the record at this point. There were no allegations in the complaint specifically addressing that. Your Honor asked, I
Right.
was responding to your question. So there is a refund policy in place. There's a price match policy in place. Internally, the company has practices that if a price discrepancy is brought to an employee's attention, that employee is supposed to address it right then and there, no questions asked. So that's the response to that specific question. But going back.
Well, go ahead.
I was going to say, going back, and Judge Lee, to your question earlier about what are the facts here. We have one plaintiff going to one store, and he finds 6 items out of the 100,000 plus items. What didn't he or any of the other testers do? They never went back to the Walmart store in Niles, Illinois. They didn't show this was repetitive at that store. All we know is there were 6 items on one day at one store. That's all the plaintiff himself did. Now let's talk about some of the other allegations in the complaint, because I would respectfully submit they highlight my point. They support my point, which is This situation is nothing other than a simple mistake. It could be caused by multiple reasons. I have a couple hypotheticals I'm happy to share with you, but it is a simple mistake. There is no factual support for any reasonable inference that this is anything other than a mistake. Contrary to the
Plaintiff has
conclusory.
could you address what plaintiff has talked about with, we're told that 2% looks like it's acceptable within the industry, or at least tolerated within the industry. We have the prior enforcement actions, fines, et cetera. We have the amicus brief saying, in essence, all this is unavoidable. It may or may not be unavoidable, but that would seem to be beyond the motion to dismiss stage.
Possibly, Your Honor, but let me address what is in the complaint and highlight why it's insufficient, which is, I would submit, what we're talking about here and why the district court appropriately concluded that the allegations in the complaint were insufficient to satisfy the requisite elements of the stated claims. So, the facts in the complaint. Plaintiff himself purchases 6 items that apparently had a mistake. 1 day, 1 store, 1 state. That's it. That's all we have for the plaintiff. With regard to the plaintiff's counsel, let's see what they found. Maryland, 1 product. 1 day, 1 store, 1 product. Pennsylvania, 1 store, 1 day, 2 products. Again, let's keep the context in mind here, because contextual analysis is appropriate, as Judge Sykes earlier noted. So context, 2 products in Pennsylvania, 4 products in Florida. We're getting into big numbers now, 6 products in New Jersey at 2 different stores.
Mr. Bloom, I guess, you know, we've all read the complaint, and we know what the allegations are in the complaint. The you know, the question that really kind of comes to mind is that it's a multi-factor test, right? As far as you look at the totality of circumstances. But certainly one is that Walmart does intend for its customers to look at the prices on the shelves and to rely on them to some extent. Now, to what extent, that's in dispute, but certainly that's why the prices are there, right? Otherwise, they wouldn't need the prices there. And as I noted, plaintiff does not have any obligations to include what I might call exculpatory allegations. And so given that's the state of the law in Illinois under the ICFA, why isn't that enough to get them past the motion to dismiss? Now, and going back to what Judge Hamilton said about, or the example about the big screen TV versus the small various items and what a reasonable consumer might do, again, that to me, why isn't that a factual issue that needs to be resolved after some discovery and perhaps at the summary judgment stage, but not at the motion to dismiss stage?
A couple of points, Your Honor. First of all, with regard to the discovery, I don't think there's any dispute that Rule 9b specificity requirements apply here given the fraud-based allegations. So,
Actually, that is an issue, given the ICFA and the allegations of just unfair practices.
I stand corrected, Your Honor. I agree with your statement that to the extent there is a separate claim here for unfair, generally speaking, the unfairness prong applies Rule 8. I will agree with that statement. However, in this context, as the district court appropriately concluded, there's claim conversion in multiple instances, and we would submit here where all of the allegations, whether deceptive or unfair, rely on an underlying allegation of fraud. In those types of situations, 9b applies.
Well, sorry, I need to pursue this for a moment, and I'll ask you to go back. But it seems to me relevant in this context would be the hypothetical about, and not so hypothetical, since it happened to me on Monday on my way to Chicago, seeing an advertised price for gas, pulling off the highway, and there's a different price at the pump. Hard to call that fraud. Right, because the actual price is disclosed to me at the pump, and I have to make a choice then. Do I go ahead and pay the extra that was not disclosed to me, or do I drive on, search for another gas station? Now, Do you think that's actionable?
First of all, with regard to the specific gas example, Your Honor, my understanding is gas pricing is subject to federal regulations. I am not an expert and I don't know, so I can't address that specific situation.
Just apply the standards of the ICFA to that fact context.
Again, it's difficult to do without more information.
How is it different from this?
Here's why, Your Honor, and this is where I was going with this a minute ago. For the unfairness prong, the law is very clear that there need to be sufficient factual allegations to establish the unfairness aspect of the claim asserted. Oppressiveness is one. In Tudor, for example, again, 25-year-old Illinois
The gas station is easy. It's easily oppressive. You pull strangers off the highway by advertising a false price and then confront them with the choice of a higher price.
Again, Your Honor, that may or may not be, I'll concede that there could be hypothetical situations. If you're out in the middle of a country and that's the only price.
Sure. How different is this, though, from, let's say, you've got a basket full of items at a Walmart cash register, and you've got 5 people in line behind you. Kids are impatient. Maybe they're crying. You going to stop and audit? Do you know anybody who stops and audits their receipts?
You asked, Your Honor, I will tell you, I've actually seen that happen where people will question. Yes, I have. Have I personally done it? I have.
What's the reaction by the people behind them?
We can only imagine.
You think
what the
Walmart
reaction
knows
would
what? You think Walmart knows how that works?
be. Your Honor, I can't answer that
Is
question.
there any better informed retailer in the country?
That I don't know the answer to that.
I'd be surprised.
I would be surprised, but I don't know the specific answer to your question. But again, the issue the issue presented here is whether there's sufficient facts taken in totality, taken in the context, to establish that this was a deceptive act, and in addition to that, that the requisite element of intent was sufficiently pled. We respectfully submit that the plaintiffs have failed their burden in that regard. All they have, going back to Judge Lee, your question about statistical analysis and what's the total set here, I'll cut to the chase. If you look at all the allegations in the complaint, they found a total of 31 items during an 8-month investigation, 11 different stores, multiple different states. 31. Now, they're going to say, well, Mr. Blumen's conveniently ignoring the other regulatory investigations. I want to address that as well. First of all, North Carolina is one of the 2 that they identify in their complaint. I want to talk about North Carolina. First and foremost, it's interesting to me that they highlight North Carolina because, Your Honors, if you look at footnotes 13 and 14 of the complaint, in which the plaintiffs identify the other states that are included in the state or the multi-state consumer fraud claims, noticeably absent is North Carolina. So even they don't believe that North Carolina is relevant, but here they are relying on a North Carolina investigation. That strikes me as curious. Secondly, with regard to North Carolina, that investigation clearly showed that the issues identified by the North Carolina regulators were store-specific. They were not systemic. Plaintiff himself acknowledges that. If memory serves me, it was paragraph 37 of the complaint, where he talks about North Carolina being store-specific problems. That's a long way away from sufficient evidence of establishing a countrywide systemic problem.
So, Mr. Blumen, let's take another look at this case, and let's assume that plaintiff was filing this case in state court, and it was an individual plaintiff, no allegations of class, and Mr. Khan says, look, I went into Walmart, I bought these 6 things, the prices were wrong, I paid more for them, I went home, and it wasn't until I got home I was able to look at the receipt, and so I'm going to bring an ICFA claim. Are you saying that that claim would not be able to survive a motion to dismiss standard?
I am saying that, Your Honor. Given that limited set of facts, if that's all we have, there's no context within which to support a reasonable inference that there
Well,
was
then what more would Mr. Khan in that situation have to allege under the ICFA?
I can't speculate as to what would get him over the hurdle, but one thing I can say, Your Honor, is there are certain states where the burden is affirmatively placed on the consumer to bring an error to the retailer's attention. I will cite specifically Michigan, and I believe if my notes are correct, this is in our brief, but it's section 445.319 of the Michigan statute. I think it's on page 7 of our brief where we highlight a couple of different states. The reason I'm raising that is it's not unreasonable for a retailer to expect that a consumer bring to the retailer's attention if an error happens. If it's an innocent mistake, that does not warrant a fraud-based claim or even an unfairness claim under the Illinois Consumer Fraud Act. Now, back to my footnotes 13 and 14 of the plaintiff's complaint. And I just referenced, Your Honor, a Michigan statute. Clearly, we're in Illinois. But it's interesting, if you go back to that same footnote, plaintiffs say Michigan consumer fraud statute is analogous to the Illinois consumer fraud statute. So, by extrapolation, I'm arguing that Michigan acknowledges the burden is on the consumer if they find an error, a one-off error.
Do you see that in Illinois law? Or are you simply trying to play off of the brief or the complaint?
Your Honor, to my knowledge, there is no express provision
I'm not aware of
identical
that.
to that under Illinois law. That is correct. But I would suggest that Illinois law is consistent with Michigan, and again, I'll direct the court's attention back to the Tudor decision, which is the only Illinois appellate court authority directly on point here. Yes, there are 2 circuit court cases, the Gohari case and the Gansberg case. We've addressed those in a brief. I'm happy to address them further if you have any questions. But Tudor is a 25-year-old Illinois
Mr. Lewin,
appellate court
I see your
decision.
time is almost up. If I could ask you a question about the point of sale thing again. In your brief, you cite to 225 Illinois statute 470-/30 and the administrative code section 600.330. My reading of those provisions is that Illinois basically adopts the National Institute of Standards and Technology handbooks, section 130 and 44. But I don't see anything in there that mandates that point of sales equipment be used. Only that if point of sale equipment is used, that it has to follow or just meet the requirements of the handbook. And I'm just trying to, is it your understanding of those provisions that mandates point of sale displays?
Your Honor, I appreciate the distinction in your question. Candidly, I would have to dig into that further. I truly don't know. I can tell you unequivocally, without hesitation, that Walmart absolutely has those point of sale screens, if you will, at checkout.
The district judge dismissed the the claim under the Uniform Deceptive Trade Practices Act, the injunctive claim, on the merits for lack of adequate allegations of a deceptive act for the same reason as the ICFA claim was dismissed. But there's an additional issue that's been raised about the imminence of any harm to this plaintiff
Yes, Your Honor.
to support the claim for injunctive relief.
Yes, Your Honor. There's 2 points here, and I see my time is over, but I'll be happy to answer your question. First of all, you're correct. The district court dismissed the Uniform Deceptive Trade Practices Act in part because there was insufficient allegations of deception, which is one of the requisite elements under that statute. In addition, and I believe we addressed this in our reply brief in the district court, that to state a claim under the Uniform Deceptive Trade Practices Act, you can't get damages under that statute, as Your Honor probably knows. But the plaintiff must allege sufficient facts that he or she, there's a likelihood of harm in the future. There's multiple cases, Robinson case, I think it's Benson, these are all cited in our brief, that stands for the proposition that once a plaintiff is aware of a situation like prices might not always match, that they're put on notice and therefore there's no risk of future harm. I would submit that's exactly applicable here. The named plaintiff, who clearly was shopping for this lawsuit and others, clearly now at a minimum should be on notice that if he's going back to a Walmart store, if he thinks there's a problem, he should look at the screen at the checkout so there's no risk of future harm.
Is this a merits question about the adequacy of the allegations or a question of standing? Injury. to support future injury, imminent future injury to support an injunctive relief, a prospective
I would have
relief
to,
claim.
I would have to think about that. Again, I know damages are not an element under that statute, and how exactly procedurally,
Well, if it's a standing question.
it would have to, it's a lack of factual allegations in the complaint to meet that requisite element under the Uniform Deceptive Trade Practices Act, I guess is how I would answer that question.
And the recovery of attorney's fees under that statute is sort of the tail wagging the dog there, presumably?
Presumably, Your Honor.
Okay, got it, thank you.
With that, I see my time has expired. If there's no other questions, I would respectfully ask this court to affirm the district court's order dismissing plaintiff's complaint in its entirety. Thank you.
Thank you. Mr. Bernstein?
I have 2:40. I'm going to use my New York minute to cover 6-7 points, and hopefully there'll be a tape and notes. Judge Hamilton asked, how do real consumers behave? That is the test under Bell v. Publix. Real consumers don't remember the price at the shelf in a Walmart. I can't even find the aisle that I was in again, I certainly can't find the price, and they're not required to. Many consumers don't notice the false price when it gets rung up, if they happen to be looking at the scanner, and even when they get home. And those people are entitled to their money back. And hundreds of thousands of people or millions can't go to the customer service desk and ask for that money back. And it's certainly not if they don't know they weren't overcharged. And the law is very clear in the state courts. There's several decisions. Consumers are not required to audit their receipts. And that's what my friends at Walmart are telling us to do. As far as misrepresentations, can an innocent misrepresentation violate ICFA? That, I think, was a question this morning. The answer in our brief and in the Attorney General's brief is yes. The Illinois Supreme Court in Leslie said that an innocent misrepresentation, Duran versus Leslie, said an innocent representation can violate ICFA. Walmart intends...
Under an unfair practice theory or under a deceptive practice theory?
Deceptive practice, I believe, is the case. That's not our case. We claim it's not an innocent misrepresentation. I'm trying my now in 13 to finish. A tutor, my friend, Mr. Bluen, mistakenly referred to in one time as an Illinois Supreme Court case. It's not Supreme Court. It's obviously the appellate court, but she referred to it later. This court has held the receipt does not cure does not create a post-sale disclosure to cure a pre-sale deception. That's Fannie Mae, and in state court Gansberg versus Kroger, which is very similar facts to ours that circuit court held. The shelf prices rejected all the arguments that Mr. Bluen made. Circuit court very recently, several months ago, in a supermarket. Judge Lefkoe held that the refund option does not obviate pre-sale deception, and that was in the Camasta versus Omaha Steaks case. And Judge Hamilton referred to the time and the gas station and driving around, a case not cited by us, but it brought, Your Honor's question reminded me of FTC versus Think Achievement by this very court. There's a time factor, and Walmart is imposing on me, now if we take everything they say, I should audit, remember the price from the shelf, remember this, remember that. And finally, national weight of measures, standards, the 2% allowance is before you get fined. The footnote 8 in the very same statement says, but consumers are always entitled to a refund for an overcharge. We won't fine you if we don't find more than 2%, but you have to get back the money. That's what we're here. Paragraph 37 of our complaint about North Carolina, Mr. Bluen read half the sentence. There were store-specific fines. The rest of the sentence says there was a $2 million statewide fine to go to pervasiveness. So, we think, and for the injunctive relief, the very last point I'm going to make, I know I'm going over, I do apologize, that the consumer knows there may be an overcharge. The cases cited by Walmart is where we're talking about a specific product, and you know that that specific product does not contain 100% natural ingredients. The cases there's several cases that say if you just know that some products may be overpriced, you don't know which, that you have a viable ICFA claim. And to that I would point to the Gansberg case and the Gohari case, both circuit court cases, and actually Levy-Coles, which was brought up this morning by Judge Lee. So motion to dismiss, inferences should be granted in our favor. We think we pled everything we needed to do. If there was something else, we'd be happy to. The story gets better and better, but this is a pleading stage. We urge a reversal, and the Attorney General put in an amicus brief that said that this situation is antithetical to ICFA.
All right, thank you very much.
Thank you so much, Your Honor.
Our thanks to all counsel. The case is taken under advisement, and we'll move to our second case this morning, which is Q Excelsior Italia SRL versus Zurich American Insurance Company. All right, Mr. Harris, whenever you're ready.
Good morning. May it please the court. Alex Harris on behalf of the appellant Q Excelsior Italia SRL, whom I'll refer to as Excelsior. And with the court's permission, I'd like to reserve 3 minutes for rebuttal.
That's fine.
Thank you. Your Honors, under normal pleading standards, Excelsior stated a claim for coverage under the policy at issue in this case, and the district court made 2 mistakes in concluding otherwise. First, it failed to recognize that Excelsior pled physical loss or damage to the Westin Rome. There's no categorical rule against showing physical loss from COVID, and indeed, Sandy Point contemplates that COVID can lead to a loss of use that's so pervasive that it renders complete dispossession of property. That's what it takes to trigger coverage under this policy, and that's exactly what we've alleged here. Specifically, that in March of 2020, the Westin Rome Hotel in Rome, Italy, was rendered uninhabitable when SARS-CoV-2 entered the hotel, circulated through the air, affixed itself to surfaces where it remained infectious for days and weeks, and was impossible to clean through normal means. Those are allegations of dispossession because those are allegations of making the entire property unsafe for any purpose and showing that the property was unfit for normal human occupancy. Under Sandy Point, that's enough to show physical loss. Second, the district court erred in denying coverage under the policy's microorganism exclusion. As we explain, that term is ambiguous, the term microorganism, as to whether it encompasses a virus like SARS-CoV-2 or COVID in the first place. And under Illinois law, ambiguous terms are always construed in favor of coverage and in favor of the policyholder. The district court broke from that principle when it denied coverage. We also respectfully urge that or submit that Crescent Plaza hotel owner v. Zurich American Insurance Company, this court's previous decision, departed from the same principle when it construed the same provision and reached the same result, finding no ambiguity with the term microorganism on that point. We therefore respectfully urge the court reconsider and overrule Crescent Plaza to the extent that it supports affirmance below. This case should be reversed, but if the panel has any doubts, we urge that it certify both of the questions that we presented to the Illinois State Supreme Court. Both questions raise important recurring issues in insurance law, which is a core state concern.
Mr. Harris, you filed this case in state and federal court, correct?
We did, yes, Your Honor.
It's pretty unusual for a plaintiff who picks a federal forum on a question of state law to then ask us to certify.
That's correct, Your Honor. But when we filed this case, there wasn't the inconsistency that we've pointed to in our brief on the questions that we presented. One, which is the first question on complete uninhabitability or uninhabitability and complete dispossession. And the second is the unambiguous, or excuse me, the microorganism exclusion and whether that's ambiguous.
So Crescent Plaza came out after you filed your complaint?
It did, Your Honor, after we filed the complaint. Before this case was dismissed, though.
Can you point us to any Illinois COVID coverage cases, appellate cases that support your position?
That support our position on the first point on the microorganism exclusion, or excuse me, on uninhabitability?
Either one.
Either one. Well, Your Honor, I think that's the point that we're trying to make, is that our case is the first that's really presented
Well,
allegations.
there are more than a dozen Illinois appellate decisions on COVID coverage that have all come out in favor of no coverage. Now, they're not identical provisions, but you know this probably far better than I do. And the Illinois court has had plenty of opportunities to take up this issue if it were unhappy with what the appellate courts were doing.
Well, respectfully, Your Honor, we submit that it hasn't because there hasn't been a case that's actually presented the kind of allegations that we have. And I think that's because of the particular facts of our loss. This is about Rome,
Well,
Italy, and
you've just gone from this question arising time after time to saying that your case is unique. Which is it?
well, I think that the first point is that complete dispossession does recur. It recurs in rare cases, but it does recur in cases, for instance, like those cited in Sandy Point, and like in our case, where a noxious substance enters a property, makes it uninhabitable. It's not that it doesn't recur, or excuse me, it's not that it recurs every day, but it does happen, and when it does happen, there should be a clear standard. The second point is on ambiguity. That's a question that does recur very often. This is an issue that is potentially live in every coverage dispute involving contract interpretation of an insurance policy. And introducing confusion into the Illinois state court standards for what constitutes ambiguity would really threaten to undermine certainty with policyholders, both in litigating these cases and in entering coverage policies in the first place. So I think these are important issues that do recur often, even if they don't recur in the specific context that we've alleged in our complaint. And again, I think I want to drive that home. This case is, the question hasn't been presented. The first question hasn't been presented to the Illinois State Supreme Court because it hasn't actually been alleged, because nobody, as far as we can tell, can allege the kind of loss that we have.
So, Mr. Harris, in your brief, you keep talking about how the COVID virus made the facilities uninhabitable for the intended purpose, and you keep talking about intended purpose. And I guess my question is, during the time in question, was there anyone on site there? Was it being used for any purpose? In other words, were there maintenance crews there? Was there equipment there? Were things being stored there? Were the tables for the ballrooms being stored there? I mean, what was going on at the property? Or was it just completely empty? Like no one could go in. There was police tape basically around it, and what was going on there?
Well, basically, to answer your second question first, there were periods where no one was inside. We pointed out that there were times, long periods, where guests were not staying in the hotel at all. And
aside from guests, were there other people
other
on site?
people? We have alleged that some staff eventually was able to return to the hotel for the purpose of remediating and making safe. But I think that that's something that is true also in the other cases that are cited favorably in Sandy Point as examples of complete dispossession. And that's the Gregory packaging case and the Matzner case about ammonia and about carbon monoxide, respectively. Both of those cases involved buildings that were rendered uninhabitable, but in both cases, maintenance workers, staff workers, were able to go inside during those periods of uninhabitability to remediate and make safe for workers and tenants, respectively, to eventually return to those buildings. And that's the same situation here. It's no different functionally. And I think that doesn't change the fact that it was uninhabitable during that period. I see that I'm running into time for rebuttal. With the court's permission, reserve that.
That's fine.
Thank you.
Ms. Cole-Ross?
Good morning, and may it please the court. Counsel, there's nothing unique about the hotel suffering economic losses in this case due to the COVID-19 pandemic. In Crescent Plaza, the Ritz-Carlton Dallas, likewise, the factual allegations were that although the hotel remained open for business, it had far fewer guests and could not use all of its facilities, only certain areas. And the same policy was at issue, the same Zurich policy was at issue, and this court held, with Judge Hamilton authoring the decision, that there was no direct physical loss or damage shown, and also that the policy's microorganism exclusion applied. So we don't have a unique circumstance here. At all times, as alleged in the operative amended complaint, and I would like to point out that the amended complaint was filed after Crescent Plaza and Sandy Point were decided. So the original complaint was filed, and a series of, a motion to dismiss and a series of briefs were filed. And Judge Feinerman denied that initial motion to dismiss as moot, denied without prejudice, allowed Excelsior to file an amended complaint. So if they could plead around Crescent Plaza and Sandy Point and that initial group of decisions, they were afforded the opportunity to do so. They could not. The operative first amended complaint acknowledges that the Excelsior was not required to close. It did not close. It continued to operate with enhanced cleaning procedures and personal protective equipment for staff and guests. That's in paragraphs 9 and paragraph 68 of the amended complaint. The hotel employed extra security staff to ensure that only staff and guests with green passes entered the premises. And that's in paragraph 68 of the amended complaint. So at no time did the hotel meet the legal standard for uninhabitability, which is set forth in Sandy Point, which says physical entry impossible, barring all use by all persons. We never had that here. As Judge Lee mentioned, the hotel was always storing equipment. The hotel was always open for business, regardless if any travelers choose to book rooms there. There was hotel staff, employees, and security using the premises at all times. So we failed to meet, plaintiff has failed to meet the legal standard for uninhabitability, and merely saying unsafe or uninhabitable in the amended complaint is not sufficient where you have factual allegations that contradict that conclusory label. And so this case is no different. If we look at Illinois law, we have the Sweetberry Cafe case, and the court held that there was no physical dispossession in that case, a restaurant where it lost use of the facility for in-person dining, but it was allowed to prepare food for carryout. And the court said where the facility can still be used for some purposes, you don't have physical dispossession. And it, like Sandy Point, it contrasted that situation to the noxious fumes, the gas infiltration cases where physical entry is impossible. All use by all persons is barred. And I would like to point out that in addition to Crescent Plaza, we have, in addition to Sweetberry, we've got the Bend Hotel in Sandy Point, was one of the three plaintiffs at issue that was a hotel. They were still allowed to remain open for lodging, but a lot of their facilities weren't used. Their occupancy was lowered. Materially indistinguishable facts from the present case, no direct physical loss or damage. We've talked about the Ritz-Carlton Dallas, same situation in Crescent Plaza. We've got the Conrad Hotel in Circle Block Partners, and I will draw the court's attention to Judge Hamilton's words in authoring the opinion in that case. Quote, because of the Conrad's status as an essential business for certain purposes, it was permitted to remain open, to provide lodging and delivery or carry out food services. In other words, the hotel was not rendered completely uninhabitable by the pandemic. Period, end quote. That really.
The Conrad case involved Indiana law.
It did.
Ms. Kohlroas, could I ask you one thing I was troubled by?
Certainly.
Judge Feinerman noted in his entry granting the motion to dismiss allegations in the complaint that Zurich had not even responded to plaintiff's claims for coverage.
I'm not sure that that is accurate. I do not know the exact timing. I'm not sure if it's of record, but they did, there was a claim for cancellation of bookings. That claim survived the motion to dismiss. It was ultimately withdrawn because coverage. The sublimit had been exhausted by other claims. So I know at some point there was an acknowledgement that there would be coverage afforded under cancellation of
At some
bookings.
point is not the standard under insurance law, however.
It isn't, and unfortunately, I do not know what the exact timing is.
We'll leave it at that.
But I will point out that although Circle Block involved Indiana law, there is discussion that the principles of Indiana law are similar to Illinois law. And so we feel that Your Honor's words in that case apply equally here. Where you have a business that is open for business, it is being used for some purposes, although not to its maximum capacity. Every Seventh Circuit case and every Illinois case that has looked at that situation has said that there is no direct physical loss or damage shown, not in those situations, and so that defeats the claim for coverage, because if you don't have physical loss or damage to start, you cannot reach coverage, you cannot reach any exclusions. Just because the question was asked about certification, the Illinois Supreme Court has already, in 3 separate cases, been asked to grant leave to review these issues and has denied review. One of those was Sweetberry. So if the court had any, the Illinois Supreme Court had any concern with how Illinois law was developing in this regard, it's had the chance to look at it and declined to do so. Sweetberry did address the dispossession, complete physical dispossession, in the same manner as Sandy Point. Again, the Illinois Supreme Court denied review. And if there are still cases percolating up through the appellate courts in Illinois, if the Illinois Supreme Court would like to weigh in on any of these issues in the future, it certainly has the ability to do so, but certification is not warranted here. If there are no further questions, I don't need the rest of my time. Thank you. We ask that the matter be affirmed.
Thank you. Mr. Harris.
Thank you, Your Honors. I'd like to start just with a point that my friend made at the very end of her argument about Sweetberry and certification. Sweetberry did not raise the question that we presented in our questions for certification, and that question is whether there's a categorical bar on showing complete dispossession through COVID. Sweetberry, the court found that the plaintiff had not sufficiently alleged complete dispossession, and indeed, there's evidence from a reading of the complaint, from a reading of that case, it seemed as though they didn't even allege facts that would have met any standard for complete dispossession as set out by this court or the state courts. The same is true in the other cases that are cited, or that that Zurich raised. Crescent Plaza, Bend Hotel, Circle Block, and again, Sweetberry, all of those cases involved a loss of intended use or a partial loss of use. And that's not the loss that we've alleged here. We've alleged a total loss of all use. We've alleged the property was unsafe for any purpose and that it was unfit for people to be inside. And I think that that's the difference here. That's how our case is different from all of those other cases. And that's why we're not actually asking the court to expand the standard for complete dispossession. We're saying that we're the rare case that does meet that standard. And again, that's because this is about this particular loss in this particular place, this particular time in the history of the pandemic. This is about the Westin Rome in March of 2020. It's the most prominent hotel, one of the most prominent public spaces in Rome, in the biggest city in the country that was hit the very hardest by the very first wave of COVID outside of China in March 2020. Thousands were dying a week in Italy. Hospitals were overrun. There wouldn't be a vaccine that was safely and widely available for over a year. This was a very dangerous time to be in Rome, and to be in a public place like the Westin Rome, to be in a place where people were active, were circulating, what meant exposing yourself to a potentially lethal threat. That's the kind of risk that was at play when one entered the hotel, as we've alleged. And that's the kind of loss, that's the kind of source of the loss that we've suffered. This is not an everyday occurrence. And that's why this is the rare case that meets the complete dispossession standard, that high bar that this court has established in Sandy Point. We urge the court to reverse the decision below, and if any doubts remain, we request that the court certify the questions to the Illinois State Supreme Court. I welcome any further questions. Otherwise, we thank the court for its time.
Thank you very much.
All right, thank
Our
you.
thanks to both counsel. The case is taken under advisement. And our third case for argument this morning is United States against Kevin Shabilsky. Mr. Brewster, whenever you're ready.
Your Honors, this is a case involving a complete surprise that occurred at the sentencing of Mr. Shabilsky. What had happened was Mr. Shabilsky was indicted in connection with a company called 5R relating to funnel glass storage and EPA violations, as well as a tax, unpaid payroll taxes for 5R, and then two subsequent companies that were formed, Pure Extractions and WLS. After a year and a half or thereabouts, and I think 1.6 million pages of discovery supplied by the government, in essence, conceded to a plea agreement that Mr. Shabilsky was not responsible and it would be dismissed with regard to any environmental concerns with regard to the funnel glass, and also with regard to 5R's payroll tax liability, it would be dismissed. And he would only be charged with the subsequent companies that he helped form and operate beginning in late 15 through 16, namely Pure Extractions and WLS. That plea agreement was forged after a lengthy proffer, and that plea agreement was forged with the clear understanding that the government may seek to assert relevant conduct in connection with the 5R liability. Mr. Shabilsky was a consultant for 5R beginning in 2013. He stayed in that same position, but had acquired 15% of the stock. Ultimately, he ended up getting 25% of the stock by January of 15, and that was on the basis of his guaranteeing loans and acquiring financing for the company. Unbeknownst to Mr. Shabilsky, when he joined in that role, 5R had been concealing major amounts of funnel glass in multiple states and had great liabilities that were concealed from Mr. Shabilsky. That's without a doubt. It's not really even subject to debate. The question then became, as he consulted for 5R, whether he was a control person and the circumstances of that particular liability as to whether it was mitigated. He was deceived at various points in time. He did sign an agreement with the IRS. I'm the person you can talk to. I'll work this out. And he went to seek loans. He borrowed money.
He was more than a consultant. He was CEO and CFO.
Yeah, he had a title, so that would allow him to attract financing and equity interest. He did. But he worked full-time at another company. He was at this company maybe once or twice every 2 weeks. That's true. But so the upshot of it is this. Plea agreement was forged, and the plea agreement states very clearly what the factual basis is, and it states that he didn't mind the shop and should have been more diligent about Pure Extractions and WLS, but he denied being a true control person, and he denied having responsibility directly for the relevant conduct. And in an email from the Assistant U.S. Attorney, Mr. Graber, to me, after the proffer, you're only going to be charged with this. We can fight it out with regard to relevant conduct at the hearing. He received acceptance for responsibility. There was a...
What do you mean he received acceptance of responsibility?
That was in the plea agreement, that he would get 3 points for acceptance of responsibility.
Any conditions attached to that?
I'm sorry?
Any conditions attached to that?
Yeah, the condition...
Reservation of rights if he were to...
The conditions are very clear, and I think that's an important point. Let's see here real quick. But with regard to the relevant conduct, it's very clear. That's a matter that's in dispute. It had been debated between us over a number of months, and he absolutely had a right to at least set forth, if it wasn't complete defense on control, it was a mitigation opportunity to show the true facts with regard to that. So the conditions are 4. It's in paragraph 8 of the plea agreement found in App 3, the record. Number 1, accept responsibility to the factors set forth in 3.E. 1, provide a full and truthful accounting. No one's accused that he did not. To withdraw, the United States is free to withdraw this recommendation if the defendant has previously engaged in conduct that's unknown to the United States. That was never a factor. It's inconsistent if he engages in any conduct between the date of the plea agreement and the sentencing hearing, which is never asserted as well. So as we went to the sentencing hearing, 4 months after the plea agreement and the PSR was in place, and incidentally, on the PSR, we filed objections and cited exhibits to every objection. We were very careful. You can look, we cited memos, we cited emails, we cited documents that were in the record. We got to the hearing, and immediately the court seemed to be put out with the idea that we'd have a hearing. We only had a single witness, which was basically an allocution of Mr. Shabilsky. At the outset, the prosecution said they're going to call 5 witnesses. Now, until that day, we weren't aware what witnesses would be called. I think we were told en route, in flight, that they're going to call 5 witnesses. The first witness was an IRS agent whose name we don't know. We just said Tim Smith, but it was a name that was not made known to us. And after his examination, when I examined, the judge immediately stated that you're not getting anything done here. That's not what we're here to talk about. And the question dealt with Mr. Shabilsky's efforts to compromise, borrow money that Mr. Smith was aware of, and why the IRS didn't respond back to that. No issue. You're not going to get anything done. You're to stop. I encourage you to move on. We've got a lot to cover, and you're spinning your wheels. It's completely irrelevant and isn't getting us anywhere. Please don't take the time to read. There was a portion of a letter I was reading. Don't take the time to read that. Okay. And I said, Judge, there's a real valid point, and the point that I wanted to address to the court was the mitigation aspects of Mr. Shabilsky met this guy one time. He followed right up. We had emails. And incidentally, this was asked about on direct as well by the prosecution. But as I tried to explain, the judge said this. Go right to it. He doesn't decide whether to accept the offer and compromise. And I said, I understand, Your Honor. Move on. And I've gotten the story here. There's only one offer. And so I couldn't even ask questions. And I said, may I say anything? You may say one sentence. And I said, and I'm not going to allow you get one sentence that I can say. And the sentence was, this goes to good faith and mitigation on this matter. That's it. You're done. Before I could complete Mr. Smith, it was essentially terminated. Later on...
This is the witness, Mr. Brewster, whose direct was about 20 minutes and you were about an hour in cross? Is that somebody else?
I heard counsel say that, but we actually counted the lines. A total amount was, the government took, with Mr. Smith, I believe it was 14 pages, and the cross-examination was 27 pages. So it was a little bit more than twice as much, or a little less than twice as much, but I was covering the same points that was covered on direct. Then, throughout the examination, it would just be interrupted or terminated an examination. Not for the government, just for the defense. Give me a little bit of, so when I put the defense...
Could you address the judge's explanation for that, which was that you were taking a different approach he understood the theory to be about who was in, or the hearing to be about who was in control of 5R's finances at the relevant times, which you all were disputing. And that's why the hearing was scheduled for this unusually lengthy sentencing proceeding.
Well, but
and then you shifted gears to trying to focus on good faith and mitigation efforts and compromise efforts by Mr. Shabilsky.
There's nothing that I shifted to, sir. All of it was in our papers in response to the PSR, our objections, and our sentencing memo, everything. There was no.
Listen, sure, it's all in the papers, and
Yeah.
you've got a very thorough sentencing memorandum, which I'm sure Judge Peterson considered carefully. But
Do you know what he said about that? Before the hearing, he said this. This is in his rendition, and this is what really gave me pause. He said, when I first read the sentencing memo, I had to say it was clear to me that based on the presentation and everything I had heard, that Mr. Shabilsky had not accepted responsibility. So before we got there, without any notice to me, he had a preconceived notion from the sentencing memo. The sentencing memo mostly dealt with Mr. Shabilsky's background, and they dealt briefly with 5R. But he had already determined that we were not going to have...
I've read the sentencing memorandum, and I see all kinds of minimization and deflection as well. I mean, obviously, Mr. Shabilsky has had a full life, has done public service. There are many good things about him, as Judge Peterson acknowledged in his explanation of the sentence. But he also was seeing, as I say, minimization and deflection, the opposite of acceptance of responsibility in that memorandum. Now, you may disagree with him,
Well,
but
this is...
in terms of spinning wheels, you've now used up more than 2/3 of your allotted argument time, and I haven't heard an error yet.
Okay. Well, obviously, there's a little bit of factual background here, but I want to say this. When Mr. Shabilsky got on the stand, I asked him to give us a little bit about himself, 10 or 15 or 20 seconds. No, you don't even get 15 or 20 seconds. Move on. He couldn't even explain any background. Give me a little bit about yourself in 15 to 20 seconds. Even that, we were under the gun. With regard to
Mr. Shabilsky had a full opportunity at allocution?
No.
No?
No. Matter of fact, when you say a lengthy sentencing here was set for the government because they called all the witnesses. We simply were there for an allocution. When I called Mr. Shabilsky for an allocution and allow cross-examination as a witness, he couldn't even say 15 to 20 seconds about himself. It was shut off. Now, the point about Judge Peterson saying he'd made up his mind, it was clear to him. If I had known that, if he would have told us going in, listen, I've kind of made up my mind about this acceptance of responsibility, we absolutely would have focused in on that. But I had no clue until the evidence was over. I had no notice of that. When you look at, obviously, the Cunningham case, this is much more egregious than the facts in Cunningham. For example, when I had Mr. Shabilsky on the stand, he just cut me off. You're done. He told me I'd have an hour. He gave me 40 minutes. After cross, when we came back for the argument, I said, could I call him briefly on a couple of issues? No. No opportunity. Now, the point clearly is this. If the government took the position that Mr. Shabilsky hadn't accepted responsibility, it certainly wasn't set forth in their motion or their objections to the PSR. The PSR recommendation is to receive that. And we didn't know the judge's predisposition on this issue, or we would have dealt with it. We had no notice of it. Incidentally...
Well, but aren't those just recommendations? I mean, the plea agreement says the government is going to recommend acceptance of responsibility. The PSR recommended, or, the granting of acceptance of responsibility. But in the end, it comes down to the judge, and a part of what the judge considers is what happens during the sentencing hearing, right? So there's nothing written in stone or agreed to that that would give Mr. Shabilsky the misimpression that those acceptance points were guaranteed.
No, the point is this. What was intended to be mitigation evidence, the judge was offended by any of it because he thought there was only a single issue, and that was control. He misapprehended our efforts to show mitigation on the relevant conduct, which we should have had a right to do. He had a preconceived notion without letting us know that so we could address that.
But weren't all those issues explored in the written submissions that you made to the judge? The objections to the PSR, the sentencing memoranda, the arguments you made at sentencing. I mean, that's what extra could you have elicited from Mr. Shabilsky during that hearing?
Well, we could have put on evidence, and I attempted to put on evidence in the mitigation, the backdrop. For example, the accountant had been there 15 years, said that Mr. Shabilsky wasn't involved in the business. I mean, there's no question, but we never had a chance.
But those things, what those people said, the prior employees, that stuff is in the record, right? I mean, they testified to what.
But the elocution is a very important part. And for the defendant to get up there, and when I asked, could you tell us a little bit about yourself? No. You don't even get 15 seconds. And also,
that wasn't during the elocution.
I'm sorry, sir.
That wasn't during elocution.
Well, it was during his I called him as a witness to allocute, as well as I knew there might be a post-hearing or post-evidentiary presentation allocution.
There has to be.
Yes.
Right, so this
And-
was during the evidentiary
And
presentation, not
incidentally,
the elocution.
he really attacked the allocution, but the allocution was nearly word for word that was in the factual basis for the plea, almost word for word.
So what would it have added?
Huh?
So,
I'm sorry,
So
sir.
are we talking about what you wanted to put on was word for word, or what you said word for word?
No, he understood his responsibility and guilt. And when he allocated very clearly, went right back, he authorized me in the statements on the plea agreement, the factual, and he restated it. I mean, and the judge then said he did not accept responsibility for the relevant conduct. And he was angry because any effort to try to show mitigation, and Cunningham really goes to this question. This is a situation where he had no real opportunity, seriously. The judge had a preconceived, as he expressed, that he clearly thought.
Well, look, judges are expected to prepare for these hearings, right? They don't shoot from the hip.
Right.
We're not shooting from the hip this morning.
Right.
And
But
so
don't you?
the judge alerted you, this is an issue.
No, not until the end. At the end, when he gave
I
sentence.
thought he told you at the very beginning.
No, not at all.
Wait, explain to me what I thought you told us earlier, he told you at the beginning of the hearing that based on the written submission, he had questions about acceptance.
No. If he would have, we might not be here. Never a hint there was any question about that.
This
It
would
was
be the
agreed-
moment if there were a court reporter that we'd ask the court reporter to read back what you just said.
Yes.
Because you just said something entirely different.
I'm sorry. No, there was no indication the court was concerned with acceptance of responsibility until the end, after the evidence was in. Then he said, when I read the sentence, it clearly appeared to me. Well, how would I have known that? We would have put on evidence.
Acceptance is always in play, okay? Your brief seems to argue that the judge was bound by your agreement with the government.
No.
He was not.
That's not my argument. My argument is if the court has a preconceived notion, and incidentally, there's so many factual errors in the decision. I don't have the time, and I won't. But the point is, like Cunningham, this allocution, this opportunity for the defendant in this solemn process to address the court's concern never had a chance. It was at the end of the evidentiary presentation by the government, and the evidence that we were trying to show through mitigation. For example, two of the people they called were already gone by the time the tax issue accrued. The accountant said that he wasn't
Mr.
involved
Brewster,
in
your
it.
time
There was
has
a number of-
expired.
I'm sorry.
Thank you.
Sorry, but I want to make it clear because
Mr. Brewster, your time has expired. That means it's time to sit down.
Thank you very much. I
you.
appreciate your audience today.
Thank you. Mr. Graber.
May it please the court, good morning, your honors. My name is Dan Graber. I'm the prosecutor that handled the case down below. Let's just start with the evidentiary hearing. The defense objected to tax loss and relevant conduct. The defense was arguing that the defendant wasn't in control of 5 hours. So Judge Peterson said, we're going to have a hearing on it. We have to have a hearing on it because I carry the burden of proof by a preponderance for reliable evidence. PSR objection, they said I had unreliable evidence, so we had to have a hearing.
And that was very clear going in.
Very
No
clear going-
surprises about that.
There's no surprise. In fact, on October 26th, the judge issues an order saying we're going to have a 4-hour hearing, and that's it to do this. That's 4 months before 6 months before. Then on the day before the hearing, the judge enters another order saying, we're doing 4 hours. I'm going to give you this much time to do the evidentiary hearing. The morning of the hearing, the judge says, Mr. Graber, what's the game plan? I got 7 witnesses, Your Honor. I'm going to put in, and I've got all 80 exhibits. Mr. Brewster, what's your game plan? I want to call the defendant. Mr. Brewster, how much time you need? I need an hour. All right, I'm going to give you an hour, give you Graber half hour for cross. We back out from that. Mr. Graber, you got 2.5 hours to put your case in. Do the best you can. I put in 5 witnesses because the first witness, Mr. Smith, the IRS agent, I do a direct on 20 minutes and it's an hour-long cross. During that cross-examination of Mr. Smith, Judge Peterson was trying to get Mr. Brewster to move on. 3 times he gave him warnings saying, move on, you're covering, move on, I get it, because what the defense tried to do was hijack the evidentiary hearing and turn it into a character mitigation argument. Basically, I want to put on a character mitigation case as opposed to our whole purpose was PSR objection tax loss. Were you in control of 5R or not? Because the tax cost goes from 197 to 858. That was the whole point of this. So Judge Peterson was trying to say, move on, please move on, please move on. Gave him 3 warnings. Finally, at the end of Mr. Smith's cross, when he's done, the judge says, look, that was not helpful. If you continue down this road, I'm going to cut you off next time after 5 minutes. The defense says, oh, okay, perfect. Not objection, not here's my offer of proof, here's all the stuff that I want to get in that you're cutting me off on. There was no cutting off by the defense by Judge Peterson. The other thing they talk about is when Mr. Shabilsky got on the stand, the judge says, just be really concise, Mr. Brewster. I think I have the gist of your contextual story here, meaning 5R had financial problems. You're saying that you have a limited role. So please focus on what Mr. Shabilsky needs to say. I feel very confident you do, Judge. I really do. Again, no objection, no saying that you're not giving me enough time. Starts out by saying, can you give me a little bit about yourself in 15 to 20 seconds? Judge Peterson says, I wouldn't even take 15 to 20 seconds. I read your sentencing memo. I saw all the exhibits. Defense counsel says, okay, including the recommendation letters? Yes, I've read all the letters and you epigraphed them repeatedly throughout your sentencing memo, so I saw them more than once. Oh, perfect. And then they launch into his argument as to why he wasn't in charge of 5R. He talks about how we had the plea agreement, paragraph 8 of the plea agreement, typical, we make a recommendation, but if you go south at the sentencing hearing, then we can pull it. He put in the Willett affidavit. It's exhibit 9. It's in the exhibit 97, where he's putting in all these emails between me and him during plea negotiations. That's not. That Judge Peterson didn't have any of that. That was filed all after the sentencing hearing. He's trying to fatten up the record for appeal on his bail pending appeal, which was the separate appeal that they filed up, going up, and this court denied it. But he threw all that in there. Judge Peterson never saw any of that stuff. But the plea agreement, they put in the Willett affidavit, the dirty lawyer that basically said Shabilsky wasn't running 5R. And I came back because I had the burden and I thoroughly discredited the Willett affidavit. When the defendant took the stand, I asked him, you're saying you're not in charge of 5R? Nope. You submitted this Willett affidavit. Now up to then, the defendant hadn't said with an affidavit, hey, I accept this. He just put it in there to just say there. So I didn't yank acceptance because the defendant wasn't backing it. Once he backed it under oath after seeing all the evidence, my 5 witnesses, my 80 exhibits, and he gets up there and backs up and says, yeah, the Willett affidavit's fine, I wasn't in charge. And I gave him a chance to recant. That was my last question on cross. He said, nope, I'm not going to recant. Fine. When the evidence was in, I told the judge, I'm yanking acceptance, Judge, because now he's crossed the line. He's lied under oath. He had a chance to not affirm. He did affirm the Willett affidavit, and then he didn't recant it. The judge allowed the parties then to have argument on that. There was no cutoff on the allegation, Judge Hamilton. No cutoff on allocution. He let the defense counsel fully allocute, he let the defendant fully allocute. There was no cutoff on that. So this whole argument about there was a surprise or that there was cutting off of the defense ability to present its case, that simply didn't happen. I've read to you the 2 points with regards to the Tim Smith cross-examination and then the defendant's direct. This argument under Cunningham, they're arguing a Rule 32 violation. There's no Rule 230 violation. Rule 32 doesn't apply. Rule 32 I-4 talks about the right to speak. It's the allocution part of the rule, not the evidentiary hearing part. So they just picked the wrong basis for an error. And Cunningham, this court did say, look, you know, unreasonable truncation. When the district court's got some things in place and it may be a barrier and there's an unreasonable truncation, we won't allow it. He had a 7-hour hearing, more than enough chance to present whatever evidence he wanted to.
3 hours beyond the allotted time.
3 hours beyond a lot of time. And you know, one thing I want to point out, in the rebuttal brief, they put in Mr. Brewster's affidavit saying, here's all the stuff I would have said and I would have done. That's raised for the first time in the rebuttal brief. That's you can't raise that the first time in a rebuttal brief. That's waived. So when they're citing that in the rebuttal brief, saying, well, here's all the stuff we would have brought in, that was never in front of Judge Peterson. There was never a Rule 10 motion to have the record supplemented. The argument in the rebuttal brief is, well, it helps to correct or provide context. No, it doesn't. They're just trying to fatten up the record because they want to prove prejudice on plain error, which they can't do. So the Rule 32 violation, there wasn't even a Rule 32 violation. They can't even get close to getting around plain error on that. On the acceptance issue, again, as the court noted, Judge Peterson, you know, when I argued, let's yank it, and we argued it, the judge said, you know what, Graber, I'm not going to, I'm going to reserve. I'm giving this guy a life preserver. I'm going to give him a chance to fix it. I want to hear a sincere, contrite, and remorseful acceptance of responsibility during allocution. Defendant gets up and allocutes, does the complete opposite. Petty, arrogant, defiant, blames everybody else, blames the IRS, blames his co-defendants, says he's a victim of fraud. Judge Peterson's jaw dropped. And he makes the comment, you know, no reasonable person sitting in this courtroom would have believed that this man accepted responsibility. That's when he yanked acceptance. Only after that. And as the court knows under 3E1.1 Note 5, district courts allowed great deference because they're an eyewitness sitting there watching the defendant allocute. So there's no clear error there, Your Honor, in terms of the acceptance being yanked. And as you noted, this plea agreement, the court wasn't even bound by the plea agreement anyway. The last issue is just the sentencing, the error, procedural error. They're arguing procedural error in sentencing, and that Judge Peterson didn't hit all the 3553A factors. He did, and I go through in my brief how he methodically marches through. The big one they talk about is character and history. If you read Judge Peterson's order, he said, you know, that's a really outrageous mischaracterization of the evidence. The first thing Judge Peterson did when he went through the 3553A is, I'm going to begin my discussion by the character of the defendant. Somewhat unusual because usually I start with the discussion of the crime. But one of the key considerations is the character of the defendant. And I think there's no doubt that apart from this conduct, Mr. Shabilsky is a well-respected person. Then the judge goes on, it's unusual, of course, that Mr. Shabilsky has letters for such prominent people, and he had such a well-known position in the state and in the community. He was a former state senator. Tommy Thompson, our governor, did a letter of recommendation. Kathy Stepp, the director of DNR, did a letter of recommendation for him. So Judge Peterson says, so how is it that we end up with a defendant who is so well regarded but has committed an offense like this? And then he goes through, there's 3 components to why he did it: compartmentalization, rationalization, and self-delusion. So Judge Peterson, first thing out of the box, he deals with character and history of the defendant, and then methodically goes through that. So that was not ignored, and it was not an issue where they're saying that there was no meaningful consideration that factor. The role of the offense, they say, again, that Judge Peterson didn't consider that. That was the whole reason for our evidentiary hearing was role. And the judge specifically found that our evidence was credible, that our witnesses were all consistent, they were corroborated with physical evidence, and contrary, the defendant lied, that he was not in control. He also argues the disparity argument that I just want to touch on real quick. The 3553A6 disparity argument. They list in their sentencing memo 7 different defendants. They give the guidelines range and say, well, look, all these guys, they're all tax defendants. Here's the range, a lot higher, and they all got probation, so you should give my guy probation. That was all in their sentencing memo. Judge Peterson said, look, I've read your sentencing memo. I've read all the pleadings that you've presented to me, and I'm giving you 33 months. In his statement of reasons, he explains the other 2 co-defendants that are similarly situated are Bonnie Denny and Jim Moss. They cooperated. They sat down and cooperated, pled guilty, and they got 5 Ks. So he did a similar situation disparity argument in looking at other co-defendants. He just didn't use it with these folks, which makes sense because with those folks, you don't know what the other 3553 factors are on those other 7 defendants.
Were any of those from within
No.
that district?
No.
And Mr. Shabilsky did get a guideline sentence?
Yeah, 33 to 41, he got 33, and that's why under Sanchez
We've
that I
said
cite-
time and again, sticking with the guidelines. I'm not personally as big a fan of the guidelines, but that's a different question. But that sticking with the guidelines takes care of disparity arguments.
Which is the argument that I was trying to make in there, in this, citing Sanchez for this court's position that and I think there's a quote is you start with a position that it's reasonable and you're within the guidelines, and there's got to be some major factor to say that it's outside of it, and in this case there simply wasn't. He hit all of the elements that he was supposed to do. That is all I have for the court. Unless the court has questions for me, I will sit down. I'd ask you to affirm the judgment of the district court. Thank you.
All right, thank you very much. Mr. Brewster, your time had expired. I will give you a brief minute to rebut. If you have something to say in conclusion, you can have a minute.
I think what's really lost is this. There's no question there was going to be the relevant conduct contested. That's what we were there for, and that's what I was there for, to show mitigation, to show what elements of control existed. What I didn't know was by having the relevant conduct evidentiary pushback that he was going to take acceptance of responsibility away. I mean, we had agreed that that could be, we can fight it out, his terms, in the courtroom with regard to relevant conduct. The guidelines was 17 in the pre-sentence investigation report. What happened was, in dealing with the relevant conduct and trying to put it in its true light through their witnesses only, the court he admittedly preconceived the belief that we weren't accepting responsibility. Mr. Shabilsky, in his allocution and on the stand, fully accepted responsibility, almost word for word, that was set in the plea agreement. So when, at the end of the hearing, when the judge shut us off on all these points, thinking it was only the control feature and that I couldn't put on mitigation evidence, and this is directly addressed, very clearly addressed in Cunningham. And also, Cientowski, which is a 2004 case, no notice. And the court says the district court did not satisfy its obligation to provide the parties with notice and an opportunity to be heard regarding enhancements.
You're going to have to wrap up. I think we have the gist.
Thank you so much. I appreciate it.
Thank you. Our thanks to both counsel. The case is taken under advisement, and the court will be in recess for a few minutes before we call the 4th case. Thank you. Our fourth case for argument this morning is Anderson Federation of Teachers against Opeta. Ms. Smith.
Good morning, Your Honors. May it please the Court. With this Court's permission, due to the increased argument time, I would like to reserve 5 minutes for rebuttal.
That's fine.
Thank you, Your Honor. Senate Enrolled Act 297 does not violate plaintiffs' First Amendment rights because it does not create a barrier to association, discriminate on the basis of viewpoint, or compel speech. Under the law, prior to enlisting the state's assistance for ease of convenience in deducting their union dues, plaintiffs receive a government advisement of their constitutional rights. The law then requires that plaintiffs complete minimal ministerial tasks, like completing the standardized form, providing it to their employer, and verifying its authenticity before accessing the state's payroll deduction system. Plaintiffs, however, remain free to associate however they see fit. The law takes no point of view on any subject, does not tie the use of the state's payroll deduction system to any particular viewpoint, or condition access to the state system on the plaintiffs accepting or opposing a particular position. It applies equally to all teachers and does not prevent union-supporting teachers from using the state's payroll deduction system. The government has—
Ms. Smith, but the requirements are targeted only towards teachers' unions, right?
They're targeted towards to teachers. Yes, this statute—
Well, the teachers that join teachers' unions, they're
Right.
members of teachers'
So it's
unions.
a subset of teachers. Yes, yes. I suppose the—
And that's the only members of unions that are required to satisfy these particular requirements.
They are the only state employee unions that are required to—
Union members, yeah.
Yes, to complete these minimal conditions, yes. But this court made clear in Walker that differentiating between two categories of unions that may hold differing viewpoints is not viewpoint discrimination as long as the law is not tied to a point of view. And here, the law is—
And I mean, I think you raise a good point. In Walker, though, the two categories were public safety employees and general employees, right?
That's correct, Your Honor.
And the list of unions under the general employee category seems like it would be a rather diverse range of unions. So you would have, for example, the teachers' unions, the public employees, you have the American Federation of State, County, and Municipal Employees that cover all sorts of people. You have lots of different types of unions that would fall within the general employee category. And so one can see how the Walker Court might look at that very wide group of unions and say, you know what, there isn't a particular, as far as kind of message that these unions want to send to get out there the public. But here you're looking at specifically a teachers union. So isn't that a meaningful distinction?
I understand Your Honor's concern. However, other courts have rejected that claim, specifically the Fourth and Sixth Circuits, where teachers' unions were the only unions that were restricted from accessing the state's payroll deduction system. And those courts said that that was not viewpoint discrimination, that was a permissible speaker-based distinction because the law was not specifically tied to or conditioned upon a viewpoint. It did not require the teachers to accept or reject any particular—
Why isn't the relevant viewpoint that I support the union, I'm a member of it, and I want to support it financially?
Because we also have other unions that are permitted to access the state's payroll deduction system. So what you're looking at is a speaker—
The problem, as Judge Barker pointed out, is this is, given your rationales, this is massively under-inclusive, right? But even if you're looking for a viewpoint, it is, I support my union and I want to financially support it. And that's not a coincidence. That's the targeted behavior here, unlike the so-called coincidental relationship in Walker.
Well, again, Your Honor, that would then apply to all state employees. That rationale would have to then apply to all state employees who are paying their union dues through the state payroll deduction system. But it doesn't, right?
You're
So
using the
union-
under-inclusiveness then to justify the statute.
In a sense, kind of, because that is a permissible speaker-based distinction. And here, Senate Enrolled Act 297 was amending a provision that was part of a larger statutory scheme that applies only to teachers. It's Indiana Code 2029. It is the collective bargaining for teachers. So by nature of the statutory scheme, it cannot apply to other state employees. The legislature would have had to have amended other numerous statutes or another generally applicable law and then made specific carve-outs. But the legislature is not required to enact mass legislation to address a concern. It can kind of go step by step. It doesn't have to address a concern in one fell swoop. So
That's a familiar concept from equal protection law. But would you also agree that in some situations, under-inclusiveness can be evidence of viewpoint discrimination? Take for example, the language from Citizens United, which notes that, in essence, regulating some speakers can be a way of regulating viewpoint.
Yes, Your Honor. Generally, the First Amendment imposes no freestanding under-inclusive limitation. It must be content or viewpoint based to look further at the under-inclusiveness. And here, again, the language of the law is facially neutral because it doesn't condition or tie access to the state's payroll deduction system on any point of view. The law says nothing about speech or association of any kind. The plaintiffs are not, or teachers in general.
Well, the fact that you just said that the law is specific to teachers. So the law doesn't have to specify that it's directed towards teachers because it's within the statutory scheme that governs teachers. And so how is it not evident that the law is basically targeting teachers who are union members?
Only union members are accessing the payroll deduction system to pay union dues. So by nature of the provision, it isn't going to apply to non-union members. So the distinction here is not between union members and non-union members. The distinction that is relevant to the analysis is between teachers who these are required to comply with the conditions and other state employees who are not required to comply with the conditions. And that's the analysis that in the distinction that was analyzed in Walker. That's the distinction that was analyzed in the Fourth and Sixth Circuits when they were looking at the specific teacher-based restrictions. And those cases are South Carolina Education Association v. Campbell and Bailey v. Callahan. So when we're looking at those restrictions or conditions, we're not looking at, because by nature of the condition, they only apply to union members. Non-union members are not accessing the system. They're not going to be subject to them. We are looking at the employees who are subject to the restriction versus the other state employees who are not subject to the restriction.
Is the theory here that teachers are just unusually susceptible to peer pressure and overcoming their wills, and they need these special protections from coercive dues collection as compared to state police officers or firemen or firefighters?
I don't think so, Your Honor. So I think the difference here is that in Indiana, teachers are the only state employees who are subject to this kind of a labor statute that requires the collective bargaining with the state. Now, the public safety...
We're talking about local governments here, right?
Pardon?
We're talking about local employees, right? And local governments, right?
So that's the state statute applies to all teachers. Yes. Now, there are some additional so public safety officers, it also permits collective bargaining for public safety officers,
And
but
that's
it does not
widespread.
require collective bargaining. So the statute is a little bit different, and it is not as extensive. There aren't as many provisions as Indiana Code 2029. And then there are, I think it's Urban Mass Transit and the Regional Transportation Authority, and then some local government personnel are permitted to collectively bargain. But teachers are already substantively treated differently under that larger statutory scheme. And what Senate Enrolled Act 297 did was simply amend a provision of that. And the plaintiffs are not challenging that larger statutory scheme. They're just simply challenging this particular provision that was amended. And so the legislature has already determined that teachers can be treated differently than, say, public safety officers.
Let me run a hypothetical by you if I could.
Sure, Your Honor.
Our focus here is on unions and union members, but let's suppose a different legislature was concerned about shareholder rights and decided to amend the corporation code to require that corporate political expenditures be reported with proof that the board of directors or a shareholder majority vote had authorized them, to make sure shareholders weren't being coerced into supporting political speech they didn't support. Would that pose a First Amendment problem, do you think?
I haven't really.
It's a speaker category, corporations.
It's possible, Your Honor. I haven't really thought through that hypothetical. I am running into my rebuttal time. If it's okay, I could try to answer that when I come back.
And maybe the legislature might pick and say, we don't want, this is a requirement that applies only to oil and gas companies and public utilities.
And that would get closer, I think.
Think about it and
Yeah.
okay, thanks. Okay.
Thank you, Your
Before you
Honor.
sit down, can I ask you to think about something as well?
Of course, Your Honor.
Lots of interesting issues in this case. I'm going to ask the other side as well. There's some suggestion in one of the amicus briefs that the general wage assignment the general statute, right, does not compel employers to honor requests for wage deductions. Now, and that seems to be different from the wage deduction statute governing teachers, because their state employers have to honor that request. My questions are, number one, is that in fact an accurate recitation of the law? And number two, does it matter?
I believe that is an accurate recitation. The general wage assignment statute does require that the wage assignment be in writing, signed by the employee personally, and agreed to in writing by the employer. So it does require the employer's agreement before they will or can deduct through the employee's paycheck. And under Indiana Code 2029, the employer is required to deduct when the teacher requests that their union dues be deducted through their paycheck. So yes, I do believe that that is an accurate recitation of the law.
And does that apply to all public employees or just teachers?
Indiana Code 2029 applies only to teachers. That's the teacher collective bargaining statute. And then the general wage assignment statute applies to essentially everyone else.
Understood, but is there a separate public sector requirement that public sector employers across the board honor wage deduction requests? In other words, have a wage deduction system in place and must use it when requested to?
For public safety officers, I'm not sure if that is mandatory. I want to say that it is, but I'm not 100%. Now, for like Urban Mass Transit and the Regional Transportation Authority, it is not mandatory. Those statutes are very minimal. I believe it's one provision, one sentence that just simply permits collective bargaining between the employee and the state.
Okay, thank you.
Thank you.
Mr. Macy.
Thank you, Your Honors. Good morning. May it please the court. I wanted to address the contention that this is a state payroll system. These, as Judge Hamilton pointed out, are local systems. Generally, they're set up through the business office of the local school corporation. And so the dues deduction has traditionally been handled between the member and the local business office of the school corporation. The second thing I wanted to point out was that while the teachers are subject to the Indiana code that was Judge Lee just referenced on collective bargaining, local school corporations also have voluntary agreements with a number of unions, like the ones Judge Lee identified in Wisconsin. They have agreements with the municipal, ASME, the municipal employees, SEIU in some circumstances. Also, municipal governments can voluntarily enter into union contracts and bargain with utility workers. United Auto Workers has specific union units. So there are a number of individual local agreements that take place, and this law only applies to teachers. I did want to address also the question that you asked about the wage assignment. Yes, the wage assignment does involve employer agreement. And traditionally, as I said, employers can agree to all kinds of wage assignments. This is the only assignment that is being singled out, says employers can't agree to. I think one of the amicus pointed out that state employees aren't allowed to bargain. I think the amicus, and I can't remember which one, said it's illegal for them, I think, to be in a union. That's not true. State employees, by statute, are allowed to be in a union, they just can't bargain. But state employees are allowed, if their employer agrees, to assign wages to a union, and a number of state employees, after they lost their bargaining rights, are still members of unions. None of that's in the record, but that statutory site is there. It's 415.17.6 explicitly permits union membership. Okay. On the issue of the viewpoint of the speaker necessarily refers to the identity of the speaker. The literal meaning of viewpoint is the place where the speaker is standing and looking at. I mean, not to get English major on it, but you ask, where do you stand on this issue? It's the position of the speaker determines the viewpoint. So laws that explicitly...
Well, but in distinguishing Walker, which you have to do,
yeah,
Walker was pre-Janus, right?
yes,
And pre-right to work in Wisconsin, I believe, right?
yes. I
We're
think
talking
it's
about
part of that same...
unions where every employee had to be a member, right?
Right.
And so that's a little different, it seems to me, from current teachers' unions in Indiana, where membership is completely optional. It's in essence open shop after Janus, and you're not paying union dues if you haven't chosen to be a member, right?
Yes, Your Honor. And in fact, even in Indiana pre-Janus, there was no agency fee allowed. It is entirely, throughout, since I've been practicing law, and I think I put it in the brief, I think it's around 1995, it's been entirely, for the last at least 30 years, Indiana teacher membership in a union has been voluntary. And unions aren't confined to use their dues simply on bargaining a contract. Unions are allowed to contribute from their general treasury to issue advocacy. They're in fact allowed to contribute to state advocacy and candidates, local candidates for school board. So unions, a contribution to a union isn't an act that has no expressive value, no associational expression. It's entirely consistent with the understanding of this court and the Supreme Court that contributing to a union is an expressive act, and it's an expressive act of association. In the Boy Scouts versus Dale case on the Supreme Court, so that it doesn't require that every member of a group agree on every issue in order for a group policy to be expressive association. So I think similarly, there's no requirement that there must be a specific identified issue to which you're contributing other than your desire to contribute to the union. And we cited, and there are many cases where strict scrutiny has been applied in situations where people seek to organize themselves financially. Judge Hamilton mentioned Citizens United. That was about joining into a corporation.
That wasn't a subsidy case.
No, I agree.
This is a subsidy case, and I'm looking for the limiting principle to your argument. You're basically arguing that speaker-based categorizations for burdens like this on access to a subsidy equate to a viewpoint discrimination or constitute viewpoint consideration because there's no way to separate the speaker from the viewpoint. As you said, the speaker stands
Yes, Your
imbued with the viewpoint, and those two things cannot be separated. Then that means that when the government legislates a subsidy, it can't distinguish between categories of recipients in terms of access to the subsidy in the first place and particular burdens on access to the subsidy if it's going to be made available on different terms to different categories. And I don't think that's the law. So I'm looking for a limiting principle in your argument. It seems to me it's pretty broad when you're talking about a subsidy case, which this is. So we have to situate this within Reagan or I think it's pronounced Reagan, and the other cases involving subsidies as opposed to speech restrictions, which is what Citizens United was all about.
I agree, Your Honor. I think the two limiting principles, one is even in Walker, the very first section of that says that a subsidy must be viewpoint neutral.
Oh, understood. That's
Okay.
but you're arguing that any speaker-based distinction is necessarily viewpoint discriminatory because you can't separate the speaker from the viewpoint.
Yes, and I'm saying if it's narrow enough, in this case it is one class, and it's not even as
Well, that was the case in Walker. It was public safety unions were excluded from the prohibition on dues deductions.
But I think that this court in Walker said that they couldn't find a meaningful distinction between the excluded class and the non-excluded class, and therefore it was not viewpoint specific. In this case, I think the distinction is meaningful. It's one class of employee, and it's one class of employee that is seeking to perform a specific act, and that's to contribute financially to the union. It's narrow. It's narrow enough.
I'm not grasping the distinction with Walker, and you do, as Judge Hamilton said, have to distinguish that case. There was one class of public employees, in that case, public safety employees, that was excluded from the ban on dues deductions under Act 10.
Yes.
Our court said that's not viewpoint discriminatory as a facial matter, and it's not a facade for actual viewpoint discrimination. And here we've got one particular category of public employees that is being burdened differently than other categories of public employees for purposes of access to the subsidy. I don't know how that doesn't fit within the four corners of what we said in Walker.
Well, respectfully, I disagree. I think in Walker, the court was saying if you choose to give to the AFSCME, if you choose to give to the utility union, you choose to give to another union, there's no meaningful relationship between all of those individual choices because they're diffuse. It's too broad. And here it is one group and it's one decision, and it is to give to the teachers union.
In Walker, isn't it also correct that the state was arguing that the public safety unions posed a special threat, concerns about labor unrest in the state police, in state prisons, and so on?
Yes.
And that's the second argument. That goes to the justification. If this is viewpoint discriminatory, what is the strength of the justification? And it was, fairly obvious in that case. I'm not sure it's obvious here. There was a need for labor peace when you're talking about first responders. And I guess the first line of justification, as I understand it's being offered in this case by the state, is that this is a valid, either rational perhaps a strong enough justification to pass strict scrutiny, the Janus prophylactic argument that this is a rational Janus prophylactic to make sure that we don't violate anybody's Janus rights. That was the first line of justification, and then the second line is sort of a labor peace argument. I'm not quite sure. We didn't get a chance to get into that in your friend's opening argument here, but there was sort of an argument that teachers are special for some reason. Maybe you understand it better than I do.
Well, no, on the first front, well,
the Janus prophylactic.
the Janus front, I don't think that's relevant. The cases this court has decided since Janus, and it's the Bennett case, I think. That type of waiver isn't necessary, and I think that's doubly important for Indiana because Janus had no effect in Indiana.
Well, the question is not whether it's necessary. That's a byproduct of Bennett. The question is whether it's permissional, whether it's a rational basis. If this is not viewpoint discriminatory, if this is viewpoint discriminatory, whether that justification is powerful enough to survive strict scrutiny.
Yes, I don't think so, in addition to the lack of effect of Janus or the rationale. But again, it's under-inclusive because Janus also applied to a number of other public employees in Indiana. Like I mentioned, utility workers, AFSCME, SEIU. There are a number of public municipal bargaining units in Indiana that this law doesn't touch.
Okay, so your under-inclusivity argument goes to justification. It doesn't go to the question of viewpoint discrimination?
It goes to both.
Okay.
It goes to both.
Maybe you can explain that distinction.
I think if the justification based on viewpoint, or the justification is under-inclusive, then you say, well, that doesn't make sense. Why are we undertaking this law? Well, it seems to be targeting a very narrow class of people. Because it's targeting a very narrow class of people, we believe it is viewpoint specific, not viewpoint neutral. That's how I would frame that argument. So I think it applies to both.
Mr. Macy, is there anything in this record about the role of teachers' unions in Indiana politics since World War II?
No, there is not. I read the Walker case, and I thought that was pretty good evidence that this was targeted at teachers, and that didn't seem to have any effect on the court. So I'm focusing mainly on the constitutional.
Well, it didn't have an effect on the majority in Walker.
Yeah. Yes, Your Honor. So the other point I think the state's trying to make, and I don't want to make the argument for them, but I think it's in their briefs and it's in the amicus, and so I'm wading in treacherous waters here. I'm just going to do it. I think what the state's trying to say is that because we, as a state, provide collective bargaining rights and collective bargaining obligations to teachers' unions, right? Whereas the state, we explicitly don't provide them to state-level employees, and all other political, or not political subdivisions, but municipal corporations, municipalities, have voluntary collective bargains. Because we have applied this collective bargaining obligation with exclusive representatives, we're essentially allowed to set the dues obligation however we want. And
This goes to collection.
right. Exactly.
And so you have to comply with state law when it comes to collection through the payroll deduction.
Exactly.
So this is not just freedom to contract, et cetera.
Right. But again,
And collective bargaining in the public sector is heavily regulated.
well, it is and it isn't in Indiana. On the municipal level, it's frankly not regulated very much at all, except in this context. And the second portion is the grant of a benefit, and this is just the same subsidy argument. The grant of a subsidy argument doesn't allow a state entity to impose viewpoint-specific requirements on the subsidy. And every employee in the state has the opportunity to make these assignments on a recurring basis without the hoops that we required, except teachers. And again, because it's teachers, it's related to the viewpoint of the speaker that's targeted, and it also undermines the state's justification for the imposition of the limitation on the subsidy.
Thank you. Ms. Smith?
If I could make 2 points, Your Honors. Plaintiffs conflate union membership with the viewpoint of the union and fail to identify what viewpoint teachers' unions express by paying their dues that other state employee unions do not express by paying their dues. And then
So you don't stipulate that unions are expressive associations?
they can be in certain contexts, but not in every context.
Is it an expressive association in this context? Are teachers' unions expressive associations?
No. Members and their unions are distinguishable. Like, members are distinguishable from the viewpoint of their union. And I have not found any court that has said that a union is inseparable from its viewpoint and that its members are inseparable from its viewpoint, which is what this court would have to find
What
for the
what
plaintiffs.
is the teachers' union empowered to do under state law?
So they are empowered to collectively bargain and for benefits and anything that benefits teachers.
Non-wage benefits?
Yes. And so
Not
there,
wages?
Pardon?
Not wages, non-wage benefits?
Yes, I believe so. And so there are numerous reasons why teachers would join a union that have nothing to do with a particular viewpoint. They get certain classroom supports and things of that nature by being part of the union that non-union members would not otherwise receive. And then I just wanted to say that irrespective of Janus, the state does have a legitimate interest in and I see that I'm over time.
Please, I was going to ask you this question anyway, so go right ahead.
The state does have a legitimate interest, in notifying employees of their constitutional rights, ensuring employees' constitutional rights are protected, safeguarding the state. And what the state is trying to do here is strike a balance between all of that and ensuring the state and employees are protected and maintaining.
In maintaining that balance, does the state make efforts to ensure that teachers are informed that they are entitled to join a union?
The unions do that. So the state is not required to do that, but I know the Attorney General does send out, I believe it's an annual notification that does include that right in it, Your Honor.
Okay, so that's the Janus prophylactic justification here, or that's what I'm calling it. Let's say we disagree that that's a rational reason because Janus is all about non-members and what their rights are, and we're talking about here are members. So what's the secondary justification?
That would be even irrespective of Janus, you're right, because in Janus, that's ensuring a knowing and voluntary waiver of those rights. And so just ensuring that an employee is notified of their rights, safeguarding the state from allegations of improper deductions.
The text of the warning that's at issue here that has to be included in the dues deduction form is all about Janus.
It's all about their constitutional rights, their First Amendment rights.
Free speech rights to avoid subsidizing union speech by not joining a union or paying. I mean, Janus was about agency fees for non-members.
What I would point out is that the advisement itself is a fact. It is not a viewpoint. A viewpoint is an opinion about a fact, and the advisement itself states a fact. It states their constitutional rights, and it doesn't state any opinion about those rights or about those facts.
So what's the justification for it? The district court held, and we really haven't had much discussion of this in oral arguments so far at all, that the warning itself about the constitutional rights is government speech.
Well, I would disagree. Obviously, the district court.
And the judge then said it's viewpoint discriminatory because it only applies to this particular small class of public employees. Therefore, we need a justification for treating this class of public employees differently. And it either needs to be a weak justification under national basis review, or it has to be a strong justification under strict scrutiny.
Before I get to the justification, I just want to make sure I heard you. Did you say that the district court found that it was compelled speech?
No, the judge said, and that's why we're here, that it was viewpoint discriminatory.
Right, that's correct. Sorry, I thought I heard
And that's
something
why
about
it was
compelled
struck down, because the judge didn't buy your justification.
So the legislature has already kind of laid out in Indiana Code 2029-11 their findings and intent of why Indiana treats teachers differently, why teachers have their own collective bargaining statute. And this is the statute that Senate Enrolled Act 297 amended. And it talks about, right, that kind of that the state has like a fundamental interest in, you know, securing harmonious and cooperative relationships with itself, the school corporations, between the teachers and the employees. And again, here the state is just kind of striking a balance instead of eliminating or completely restricting access to the payroll deduction system in providing a standardized form and having the employee verify its authenticity to then access the state's payroll deduction system.
But those findings were entered before the revisions at issue here, right? Before the statutes at issue. Those findings were about why teachers are given collective bargaining rights writ large and why we have this whole chapter, as opposed to why we need these particular requirements that brings us all here today for teachers specifically.
Well, again, I would just go back to that the legislature is not required to enact mass legislation, and the legislature could go and enact similar legislation for public safety employees or any other employees where collective bargaining is regulated. But because this law has been embroiled in litigation since its enactment, it's reasonable that the legislature has not attempted to enact similar litigation related to other state employees until this litigation is resolved.
Is Walker involved a statewide ban on public employees' access to payroll deductions? Or as relevant here, there were other issues too. It was a broad spectrum attack on Act 10. But as relevant here, it involved a state law prohibiting public employees, all general public employees, from having access to the payroll deduction system for union dues, except for there was a carve-out for public safety unions. We said the carve-out was okay, was not viewpoint discriminatory because it was speaker-based, and that it also had a rational basis to preserve labor peace in the context of first responders. This is different. This is not an exception to a prohibition on access to a subsidy. This is a targeted condition on access to a subsidy. The condition is targeted at teachers' union members only. Is that distinction in any way material on how Walker applies here?
No, Your Honor, because still we're looking at the distinction between the unions that have these conditions and the unions that do not have these conditions. And that is what makes this a permissible speaker-based distinction. And that's exactly what Walker was talking about, and that's what the Fourth and Sixth Circuits found in South Carolina Education and Bailey.
Okay, thank you.
All right, thank you, Your Honors.
All right, our thanks to all counsel. The case is taken under advisement. We'll move to our fourth case this morning. United States against Stenson. Mr. Jensen, good morning. It's been a while.
Yes, it has. It's an honor to be here. I'm Jeffrey Jensen, and I represent the defendant, appellant Donald Stenson, and since this is the fourth or fifth argument of the morning, the court will be pleased to hear that I think the issue presented in this single issue appeal is breathtakingly simple. The question is whether the district court erroneously exercised its discretion in denying Mr. Stenson's pre-sentencing motion to withdraw his guilty pleas. Rule 11 is also one of the more simpler laws on the books. It simply says that where a defendant moves to withdraw his guilty pleas before sentencing, and he can show that he has any fair and just reason for doing so, the court should grant the motion.
May grant the motion.
Should grant the motion to allow him to withdraw the plea if he shows a fair and just reason for doing so. And the problem in this case, I don't think, was the fair and just reason. Mr. Stenson proffered 3 reasons in his motion. One is he didn't have enough time to talk to his lawyer. 2, that he was not satisfied with his lawyer's efforts in investigating the case. And 3rd, and I think this is the most important one, that on the morning of his plea hearing, he took some clonazepam, which was interfering with his ability to understand the proceedings and to properly answer the questions. Nobody, I think, is suggesting that, especially number 3, would not be a fair and just reason to allow him to withdraw the plea because it implicates the voluntariness of the plea. At the motion hearing, Mr. Stenson testified that on the morning of his plea hearing, he was feeling particularly anxious and nervous, so he took a clonazepam, which is a medication, he said, that was prescribed to him to help him sleep and to help deal with his anxiety, and that it interfered with his ability to understand what he was doing. In his words, it made him very compliant. He was just answering yes to everything, every question that the court was asking him. The court denied the motion for 2 reasons. One is the court cited to one of this court's decisions, United States versus Hardiman, in which the court said, in order to succeed on this type of a allegation that your medication interfered with your ability to understand, you ought to present an affidavit from a doctor at the minimum explaining how the medication interfered with your ability to understand the proceedings. And second of all, apparently looking at the totality of the record, the judge noted that on the plea agreement, Mr. Stenson said that at the time he signed the plea agreement, he was not under the influence of any drugs or alcohol, and there was testimony that the plea agreement was signed on the day the plea was entered, so the district court drew an inference that it was done shortly before the plea hearing took place. Now here's where I believe the court erroneously exercised its discretion. A close reading of Hardiman shows that it's distinguishable on 2 important facts, and not only that, there's language in there that arguably supports Stenson's claim to withdraw his plea. In Hardiman, during the plea colloquy, the judge asked him, "Are you on any prescription medication?" Things of that nature, and Hardiman told the judge that he was, but he didn't think it was interfering with his ability to understand what was going on, so they proceeded. In this case, in Stenson's case, there was no question from the judge to Mr. Stenson as to whether he was on medication that morning. And I think that is a huge distinction between Hardiman and Stenson's case. And then second of all, in Hardiman, the nature of the medication that Hardiman was using was psychotropic medication, which is designed and intended to help clarify people's thinking, to help them overcome the symptoms of whatever mental illness they have so that they can participate in a plea colloquy. Whereas, on the other hand here, Stenson's medication was clonazepam, which is designed to sedate people, to calm them down and to address their anxiety. So I don't think Hardiman's admonition that an affidavit from a doctor is a categorical requirement for a motion to withdraw a guilty plea for this reason. Stenson testified that he took the medication. He testified to that the medication was doing what it is intended and is designed to do. This wasn't a side effect. And consequently, he became overly compliant and said yes to all of the court's questions. The government presented no evidence to the contrary, so there was no real question of fact about that. It was just the district judge saying, I don't believe you because you didn't submit the affidavit from a doctor, and you said in the plea questionnaire that you were not under the influence of drugs or alcohol.
How is the district court to know what the effects or side effects of any particular medication is? We're not physicians, and generally speaking, we don't take the word of lay people on what the impacts or effects of drugs are. And so I think your argument is the district court, just in the absence of any opposing evidence, just should have taken Mr. Stenson's word for what the drug did to him and just go on from there.
Yes.
And so what if the district judge, as the testimony was going on, went online, looked at WebMD, and found something contrary? Would that be enough for district court to say, well, I don't really think you're right because, WebMD says something different? And so it's Mr. Stenson's burden to prove just and fair reason. And I think it puts the district courts in a very difficult position to understand exactly what the impacts of particular types of medication are without some, and I think that's kind of probably the source of Judge Posner's kind of reasoning that, it would be good to have an expert talk about this.
Somehow I knew that question was going to be answered, so I have the answer. And this isn't a matter of Donald Stenson offering a layman's opinion in the abstract about how clonazepam can affect a person. This is Donald Stenson telling Judge Edelman, I took this medication and here's how it affected me. So I think that switches the burden probably to the government to say clonazepam wouldn't affect a person that way. So there is evidence in the record, and there's really nothing to the contrary. Granted, it is Mr. Stenson's layperson's testimony, but it is from firsthand experience. He's describing how this medication actually did affect him. We're not talking about it in the abstract.
Does it matter that the judge also was drawing on his observations of Mr. Stenson during the plea colloquy?
Again, I'm glad you asked that question because there's language in Hardiman that specifically addresses that, and it's at page 943. The court wrote, a judge is required to investigate the defendant's mental state if there are indications at the plea hearing or later of an impairment that made him incompetent to plead. And here's the important language. The fact that a defendant seems competent when answering the judge's questions at the plea hearing should not be conclusive. Mental diseases or mental impairments brought on by psychotropic drugs might alter the premises of a person's thinking rather than the articulation of his thoughts. And that's what Stenson testified to.
Not conclusive, but something that the judge may consider.
Yes, but not conclusive.
I mean, it seems to me that the problem you're facing here is the abuse of discretion standard. Different judges might have responded to this in different ways.
Right. I was afraid one of the judges would ask me, isn't this a factual finding subject to the clearly erroneous standard? And my answer to that is, I don't think so, because Judge Edelman specifically relied heavily on Hardiman in his decision, that the evidence was sufficient primarily because you didn't submit an affidavit from a doctor. So I think it's a question of law, not of fact.
Thank you.
Thank you.
Mr. Klayman.
Good afternoon, Your Honors, and may it please the Court. William Clayman for the United States. The District Court acted well within its discretion here when it found that Mr. Stinson pleaded guilty knowingly and voluntarily. It based that decision based on its own observations of Mr. Stinson at the plea hearing, Mr. Stinson's responses to the court during the plea colloquy, Mr. Stinson's and his counsel's assurances to the court in the plea agreement that he told the court he reviewed and signed the same morning as his plea hearing. I wanted to briefly address my friend on the other side's arguments regarding Hardiman, which I believe he focused on primarily. As an initial matter, I don't think it's a fair reading of Judge Edelman's decision to say that he found that the only way to provide a fair and just reason to withdraw your guilty plea on this basis is through a medical affidavit. I think the better and more complete reading of the decision is that Mr. Stinson's claim or rather the evidence Mr. Stinson put forward was meager and conclusory and contradicted by what was otherwise in the record. And it was lacking the kind of substantial and specific evidence that the court would look for in these sort of circumstances. And while that would most often include probably some sort of affidavit from a doctor who was treating the defendant or some doctor who could otherwise opine on this sort of claim, that's not the only kind of specific evidence. The affidavit Mr. Stinson submitted, for example, stated in conclusory fashion that he had taken clonazepam, suffered some sort of vague side effects, and was therefore unable to plead guilty voluntarily. But he did not specify when he took that medication, how much of it he took, whether anyone saw him take it. He didn't provide any proof that he actually has that medication. He could have provided an affidavit from a member of his defense team who could corroborate or contextualize his behavior from that morning, an affidavit from a friend or family member who could confirm that he was in fact taking and even abusing this sort of medication. None of that is in the record here. Those evidentiary deficiencies are entirely attributable to Mr. Stinson, and the district court acted well within its discretion when it credited its own observations of Mr. Stinson and the voluntariness of his plea over his after-the-fact and conclusory allegations to the contrary. Unless the court has any specific questions, we would rest on our briefs and ask that you affirm the judgment below.
I guess I would just invite the comment. This is one of the shortest plea colloquies I've seen in the federal courts, and I frankly was a little surprised that there wasn't a question about medication in the face-to-face give and take. Is that common in the Eastern District? Or?
So I don't practice typically in the Eastern District of Wisconsin, so I can't say for certain. I think we would all agree it would be.
You're from D.C., okay.
Yes.
Okay.
Certainly it would be good practice to ask that question, but I think as both parties recognize, it's not legally deficient. It's not a Rule 11 violation to not ask that question. And I think in this case, it certainly wasn't reversible error.
Okay, thank you.
Thank you. Mr. Jensen, you had, your time had expired, but you can have some additional time for rebuttal.
Right, if Judge Hamilton would like an answer to the question about the Eastern District, I could answer that if you still want me to.
Sure, go ahead.
The judges in the Eastern District run the gamut in their plea colloquies. For example, Judge Pepper, you will be there for an hour while she goes through all of this with the defendant, whereas Judge Edelman, that's a fairly common plea colloquy that you saw on the record here. And the only point of rebuttal I want to raise is that I think it is a fair reading of Judge Edelman's decision that he relied almost exclusively on Hardiman. It's in the record. I don't need to read it to you, but he cites the language from Hardiman to make a case for being permitted to withdraw a guilty plea when the judge's inquiries at the plea hearing had been adequate. It requires an affidavit. And here, not only was there not an inquiry at the plea colloquy, there was testimony that the drug was doing what it was supposed to do, not some little-known side effect. So I would ask the court to reverse Judge Edelman's order and remand the matter with instructions to grant the motion.
Thank you very much. Our thanks to both counsel. The case is taken under advisement. And we'll move to our last case this morning, Darrell Burton versus Will County Sheriff's Merit Commission. Mr. Goldman, come on up.
Good morning, good afternoon, Your Honors. May it please the Court, I'm Jonathan Goldman, and I represent Daryl Burton. And this is an appeal of a case that was dismissed on a summary judgment. Mr. Burton applied for a position as a sheriff's deputy with the Will County Sheriff. That is done by applying with the Will County Sheriff Merit Commission, which conducts a variety of tests, interviews candidates, and develops a list of candidates from which the Sheriff's Office chooses deputies to hire. In Mr. Burton's situation, after he submitted the short form application, a long form application, passed a physical agility test, passed a personality test, and a polygraph exam, and then submitted the information about that was necessary for the commission to do a background investigation, he was simply waiting to be interviewed and was told that the application had been rejected. No justification for the rejection was given until after the district court case was filed. This happened back in 2012. Because of the EEOC investigation, the complaint was not filed until 2019, I think it was. I'm going to discuss two primary issues. The first being that this court should find that there is jurisdiction over the Merit Commission pursuant to the principles articulated in the Lies versus City of Riviera Beach case. And two, that there's sufficient evidence of discrimination to warrant a trial. First, this court should determine that there is jurisdiction over the Merit Commission.
Mr. Goldman, could I ask you to address the points in reverse, please? In
Sure.
other words, what is your best evidence that the Merit Commission's decision was motivated by racial animus?
Yes, Your Honor. Okay, well, we've put forth a number of theories in our brief in the court below, but the bottom line is that there are a number of facts that call into question the motivation of the commission in rejecting the appellant's application. As I had mentioned, the appellant passed the written exam and the psychological exam and the polygraph exam, but before he could be called for an interview, his application was rejected. Well, initially, it should be clear that the appellant is African American and that this was known to the commission. There's some dispute about that, but since he disclosed his race in multiple ways throughout the application process, including the fingerprint card which contained his race, there was a photograph taken of him so that they could identify him. The commission could identify.
The reason it seems that the commission gave for not including Mr. Burton on the final list was the comments that they received from CN, right? Mr. Burton's then employer. And the commission just didn't like what the CN supervisors said. And so I guess the question becomes, and your claim is that that's pretextual, that that's not the real reason why he did not make the list. And so I guess my question is, what's your best evidence of pretext?
Well, the issue with the investigation itself is really where there's a number of issues that call into question the commission's ultimate decision here. There was that statement from the supervisor, but the investigator shouldn't even have been talking to the supervisor in the first place. This is a human resources issue. Is this person, is this someone who would be promoted? And is this somebody who you would suggest for a position at the sheriff?
Wait, are you saying somebody else at CN should have talked to the investigator?
Well, the original background investigation questionnaire went to the Human Resources Department.
So what? I mean, if once the commission has a bad reference from the guy who knows his work best, what's wrong with that?
Well, the other thing was that the information that came out through the investigation should have prompted the commission, should have prompted the investigator to look a little bit more clearly at it. I mean,
How hard do they have to look? I mean,
the supervisor's, part of the supervisor's justification for his answer was that Mr. Burton had claimed that he had an on-the-job injury and that, let's see, I want to get the exact wording right.
it was questionable. So,
Yes, thank you. It was a questionable on-the-job injury, which calls into question, are they going to take some retaliatory action against Mr. Burton for his claim of an on-the-job injury, which is a violation of state law. It's a violation of Illinois public policy, and that should have prompted the investigator, that should have prompted the commission to take a step back.
as a matter of best practices, I mean, I can understand second guessing this a little bit, but I mean, if you're in the position of evaluating a number of applicants, how much time do you have to invest in any particular one?
Well, this is a very big issue for Mr. Burton. He wanted to be a sheriff's deputy. He expected to be given, full consideration for the position. I point that out in order to bring attention to the fact that this was, there were a lot of non-standard things that had taken place. Along with the investigator not really doing a full, complete investigation. You have the commissioner himself, one of the commissioners who was on the commission at the time that Mr. Burton made the application, who had made some racist remarks about another member of the commission by calling him a racist name, essentially. And each one of these things in and of themselves may not be...
The term was what, that he was the colored member of the commission?
Yes.
Okay. Did you offer any evidence of comparators? There's other applicants who had similar negative employer references who were treated more favorably than Mr. Burton?
Well, through the statistical analysis that we provided at the district court level, we did show that the minorities, the non-white applicants for the position that we were able to identify as being non-white, had been had not gotten the. There was a statistical.
They had a lower rate of certification, as I recall.
Thank you.
But
yes.
That's not really responsive to my question. Did you find and submit to the district court comparators of applicants who had similar negative employer references who were treated more favorably?
Not at the district court level, no. That was not presented to the district court.
I mean, that would seem to me the strongest possible evidence of pretext or racial animus here.
Well, I can't say exactly what went on during the discovery stage at the district court level. I was not directly involved with that, but apparently that information had not. We didn't have information like that at the district court level. And Judge Lee, you had asked, some of the things that we have to show that there was some. You had asked me to go into the issue of sufficient evidence. And again, these are a number of issues that may not on their own have tipped the scale, but together they show that there was some fishiness going on. There was a question with regard to the questionnaire. The questionnaire has a box about whether you would recommend the person for this position, and if not, why. And the secretary of the commission testified that if there's no indication in there, if there's no helpful information about why, then we don't usually look at that as a red flag. We don't present it to the commission. But even with that box checked and no specific information provided under that box, it was still presented to the commission.
Your time has expired.
Okay, thank you. I
Thank you.
have some time for rebuttal. Thank you.
Actually, your time has expired, but I'll give you a little bit of time in rebuttal.
Okay, thank you.
Mr. Fowler?
Thank you. May it please the court. This is a case alleging race discrimination from an applicant who was unsuccessful when his then current employer gave what is admittedly and objectively a bad reference. There's no dispute about that. The arguments that the appellant has made simply don't support his position. Number one, he referenced, and I'll take it in this order, he says that the commission's explanation shouldn't be credited because according to the testimony of Ms. Taylor, she says that if it's only a recommendation against hire without any explanation, she wouldn't give that to the commission. But she very clearly testified that she viewed this recommendation, when viewed in its context, as a red flag, and that when she perceives something as a red flag, she takes it to the commission. This wasn't simply a matter of a box being checked without an explanation. The reference itself contains sufficient information. Mr. Goldman mentioned that Mr. Norberg, who is the commissioner, made what he calls a racist comment. Judge Hamilton is exactly correct. The comment was that Mr. Norberg referred to one of his equals, somebody else on the commission, using the term colored. Admittedly, that's not a politically correct term. It is not a racist term. And more to the point, it doesn't show any animosity based on race. It doesn't have anything to do with the plaintiff or with the circumstances of the plaintiff not being considered for the job anymore. And under the cases that this court has referred to repeatedly, it's a stray comment. Counsel refers to his statistics argument, but the statistics argument, as the district court recognized, statistics is only helpful when there is other evidence of discrimination. It can't create evidence of discrimination in and of itself because statistics don't show the cause. They don't show the causal factor. And here, it was up to the plaintiff to come up with some evidence of his race being a causal factor. He didn't.
Mr. Fowler, I guess I'm still kind of troubled by it when I look at these numbers. 2 out of 6 minority candidates are certified, 1/3, and more than 3/4 of white candidates are certified.
So first, the numbers are based upon self-reporting. The numbers don't include everybody who applied. That is a limitation in and of itself. As I recall, when you look at the charts of the applicant flow, there were about 288 people who applied. There were 8 people who were offered jobs. When you look at those numbers, and specifically the number of people who were ultimately successful, that doesn't show, it's not a big enough sample size without going into the reasons for statistics to be helpful. I agree with Your Honor that at first blush, I understand why counsel makes the argument, but the reality is when considered in the totality here, it's just not enough to carry the day. Finally, counsel argues about the reasonableness of Sergeant Ackerberg's background investigation. But what he doesn't note is that in the 56.1 response, he specifically admitted the following, that Ackerson conducted all background investigations for hire consistent with the guidelines of such policies and the procedures manual of the Sheriff's Department. He didn't violate any standards. He didn't not do something that he should have done. He did exactly what he was supposed to do. And that doesn't allow a basis for claiming that race played a factor. Finally, counsel argues about the failure to disclose the reason. But again, we've made it clear in the briefs This is something that county ordinance did not allow anybody to tell Mr. Burton why he wasn't selected, why he was removed from the process. As soon as we filed our answer to the complaint, we voluntarily and immediately notified plaintiff's counsel what had happened, what was going on. That was the first opportunity to do so. The fact that it hadn't been done beforehand because of the county ordinance is not an indicia of race discrimination. With that, I think that our briefs are pretty thorough, and unless the panel has other questions, I'd be happy to stand on the briefs. Thank you. With that, we then ask that the court affirm the decision of the district court granting summary judgment to the employer.
Thank you. Mr. Goldman, I'll give you a minute in rebuttal.
I just wanted to point out one thing with regard to the commissioner's comment. This is the only indication of what kind of things went on at the commission decision-making level. And here's a gentleman who referred to one of his other commissioners in this way, using a very outdated and to date racist, in my opinion, language, and yet he, and this was in a deposition about a race discrimination case. So one can only imagine, how this gentleman really felt about African Americans and how he speaks about them in an informal way. And with that, we request that the decision of the district court be reversed and that this case be remanded for trial. Thank you.
Thank you very much. Our thanks to both counsel. The case is taken under advisement, and that concludes the court's calendar for today. The court is in recess.